Facilities Management Committee. Tuesday, September 29th. The overall public building. We have several items today, and I understand we have quite a few folks and seniors in the audience that I want to be able to respond to, and so we'll take some items out of order. We do have a quorum, and I thank Councilman Rizal for joining us this afternoon. And as you can tell, the acoustics are not the best in this room. So we need to have a conversation. Please take it outside. When you do come up to the microphone, give us your name and address. You keep your eye on the clock. We'll either do 2 or 1 minute, depending on the item. Many of you have written a very eloquent letter. And you find yourself with a 1 minute, please get to your point as soon as possible. Same thing if it's a 2 minute mark. If the person before you has made the same statement or comment and you agree with it, it's okay to say, I agree with the previous speaker, and add anything new. So that we can keep the committee meeting moving. Just been joined by Councilman Zine. We're all just leaving City Council, which is still probably going on. Well, thank you, Councilman Zine.
You're up.
So what we'll do is, out of courtesy to
What's up?
the folks on who are elderly here, I understand we might have a person, you have to say who you are, but congratulations on being 95. I want to pay respect to our elders on that, in that level. So what we'll do is we'll go with item number 10 first, Roberto.
Item 10, Councilman, is an appeal. It has to do with the action of the Planning Commission, which sustained a decision of the advisory agency for the disapproval of a tract map for the conversion of an apartment building into 100-unit condominium complex in CD2.
Okay, good afternoon.
Good afternoon, Chairman Reyes and members of the committee. My name is Lynn Harper. I was the Deputy Advisory Agency on this case. As was previously stated, it is an appeal of a denial of a conversion of a 104-unit apartment complex into a 100-unit condominium complex. The site is approximately 4.4 acres in the RD 1.5 zone in the Van Nuys North Sherman Oaks Community Plan. This conversion project had been attempted previously in January 2007. The applicants applied for a condo conversion, and in January 2008, that conversion was denied based on the findings by the advisory agency that they were not substantially in compliance with the 80-day notification requirement from the State Subdivision Map Act, and that the cumulative negative impact on the rental housing stock would be significant. The applicant again applied in June of 2008, almost identical application to convert the 104 apartments into 100 condos. And again, a public hearing was held in February of this year in 2009, and on March 5th of 2009, the advisory agency again issued a denial based essentially on the same issues of substantial nonconformance with the 80-day notice in the Subdivision Map Act, and that the project would create a cumulative negative impact on the rental housing stock. Now, I'm happy to go into the details about all of this, but before I do that, I'd like to know if that's what you want, or
Can you just highlight perhaps
okay.
one or two that you feel are the most
Okay,
just profound in nature?
yeah. Perhaps there are a couple of major sticking points about the State Subdivision Map Act and the 80-day notification in this case. There were two units for which the planning staff could not find any record that the applicant subdivider had sent notification. They either have to provide a record that they sent notification, or they have to provide some kind of proof. You know, we don't specify exactly what that is, but some kind of proof that those units were vacant. And we were unable to obtain either of those pieces of documentation. Later on in the process, I think it was when their appeal went before the City Planning Commission, they presented proof that in 2008, the then tenants had been notified that that the building might be converted and that they were not eligible for relocation, but we have no evidence that either of those two subject units were vacant or notified in a timely manner in 2007. The second sticking point here is, in terms of the notice, is that on January 29th, 2009, just a few days before the February 5th, 2009 public hearing, there was a notice circulated. I was told at the hearing that the notice was circulated to every tenant, and basically, and I quote that notice on page 5 of the staff report, telling the tenants that the condo conversion was off the books and was not happening, and don't panic and don't listen to rumors, et cetera, et cetera. At the public hearing, almost everybody who testified against the condo conversion were quite upset and concerned about this notice, and felt that it had a misleading and chilling effect on the discussion and the tenants' understanding of what their rights were, and was in violation of the law. The other sticking point is about the cumulative impact on the rental housing market and the vacancy rate. Consistently, as we looked back over the last few years, the vacancy rate in the Van Nuys area has been hovering between around 3.2, I think, was the low. And I understand as of today, in January 2009, it's around 4. Our municipal code says that if the vacancy rate is below 5%, and if the advisory agency also finds that the conversion of the project will result in a negative cumulative impact on the rental stock market, that the advisory agency therefore cannot make the proper findings in the affirmative, and therefore must deny the project. So, in summary, because of the problems with the notification, and that's according to the State Subdivision Map Act, and because as the Deputy Advisory Agency I couldn't make the findings regarding the vacancy rate and the cumulative impact on the rental market, I denied the case.
Thank you, Ms. Harper. Any questions from my colleagues? Seeing none?
Okay.
I'd like to ask the appellant, thank you, Ms. Harper. I'd like to ask the appellant on this case, like to come on up and give us the reasons for your appeal.
Good morning, good afternoon, council member, chairman, and other council members. The reason we've appealed is because we feel that the city has erred in certainly the notice issues and as well as the cumulative impact issue. On the notice issues, I'll speak briefly. Those two units that Ms. Harper refers to were vacant. We've provided move-out dates, new move-in dates, new leases, and new waivers by the new tenants that moved in during the notice period.
Sorry, just for the record, can you say your name and address?
Sorry. My name is Brian Dror. I am the manager of the LLC, which is the managing entity of SMH Magnolia Condominiums LLC, which is the owner of the property. And my address is 5967 West 3rd Street, suite number 102, Los Angeles, California, 90036.
Thank you, sir.
My apologies. As far as the second issue of notice, to say that a undated, unsigned letter from the on-site manager done for the purposes of trying to calm people down that were being told they were going to be kicked out into the streets hardly negates what the advisory agency referred to as the 60-day Subdivision Map Act notice requirement. We have it from our legal authorities, and I'd be happy to defer to the city attorney on this, that the 60-day notice that's discussed in the MAP Act solely talks about in advance of filing the application, that 60-day notice does not carry any continuing obligations or ramifications from that point forward. And we did have significantly longer because we had the issues with the first application on the notice that we hired a law firm to go ahead and make sure. It took 3 months to make sure, because the tenants were not accepting their certified notices or their mail. We made sure that everything was done properly, exactly as needed to be. It took us over 3 months to get the notices done properly. We then waited more than 60 days to file the application. So we actually feel that we are in compliance with the Subdivision Map Act this time, and that the city has made a mistake in determining that notice had any chilling effect. There were a number of tenants that showed up to the hearing. They had representation by 2 attorneys as well as the Coalition for Economic Survival. And the version of the notice that I saw actually on its face says that the conversion is continuing on paper or for legal purposes only, and therefore should have had no effect on anybody's opportunity to participate in a hearing. The item I'd really like to focus on is the cumulative effect. We've offered an enhanced package as far as notice time, as far as relocation benefits, as far as a number of other items that, above and beyond the mandated items by the City Council and by ordinance, we feel more than mitigates the cumulative effect that this would have. Some of the things that we've talked about, I'm not sure if the committee is all up to date on what we've talked about, but we've talked about a no notice period, that we would not give notices to vacate for the conversion for a period of 4 years. We have also said that rather than giving certain tenants 120 days to vacate after their notice, and that disabled or elderly tenants that request in the first 60 days to have a year extension, or their notice period extended up to a year, we would give everybody the 1 year notice period, not just those that properly ask for it in the first 60 days. We also discussed that we would allow, even though it's not required by the ordinance, that we would allow relocation amounts be used towards a down payment if tenants are able to or willing to purchase their units when the time came. So even though they're not being relocated, we would still give them those dollars as a benefit towards their down payment, and that would help them with their financing requirements. We further offered that anyone who is over age 80 or has been in the property for 25 years or more would never be asked to vacate the property. We would keep them in place under their current rent-stabilized rental agreements, and we would continue to own those units so that they could remain in those units without any change or effect to their tenancy. We also offered, depending on, I don't have to get into all the details unless you ask me to, but we've offered other enhanced benefits as well. And I'm also, I asked Ms. Harper at the initial hearing what more she felt would be necessary.
This is your opportunity to share your thoughts. If you'd like to conclude, that would be great.
I'm done.
You're done? Okay.
So I feel that we've covered the 3 points. 2 of them are more legal issues for the city attorney to address than myself. But on the cumulative effect, we feel that our enhanced benefit package certainly far outweighs any impact.
Okay. Colleagues, any questions for the appellant?
I have a question, Mr. Chair.
Yes, sir.
You made a comment regarding 80 years of age, if they lived there 25 years or more.
Yes,
What
sir.
about a person that's 80 years of age or 78 years of age that's lived there for 1 or 2 years? Would they be displaced?
No, sir. It's 2 separate. I'm sorry if I wasn't clear. It's 2 separate qualifications.
Okay.
Anyone who is 80 years or above, or anyone who has lived there for 25 years. These were issues that we addressed because in the initial hearing, these were some of the comments that were made by some of the tenants. We had a 91-year-old woman. I didn't want her to think that she was ever going to be displaced. We had a 83-year-old, we had someone who had lived there since it was built 40 years ago. We wanted to address the issues, the legitimate issues that were brought up.
Because they've obviously been good tenants, been faithful tenants, paid their rent.
Fantastic.
And to be displaced at that age would, I'm sure, be heartbreaking for them and very traumatic. The age breakdown, how many in the 70, 80, 90 range of your tenants? I understand there's 104 units existing now.
I believe it's actually a fairly small number, but
Do you have a breakdown, though?
I want to say it's eight or nine of the units are affected by either the 80 or above or 25 years or longer. So it's
Like
probably
8 or 9
it's
combination
probably
of both?
Yes, yeah. It's 8 or 9 units are affected
Of the 104?
of the 104.
So it's
correct.
and the average occupancy is how long of your other tenants?
I believe it's somewhere around 10 years is the average occupancy for the overall building.
That's a long time
Yes, sir.
for apartments. Very long time.
It's a beautiful property in a beautiful location.
Okay, thank you. Thank you, Mr. Chair.
Mr. Chair, you just presented or mentioned a new tenant package. Has that been presented to the tenants, or is this something that you're presenting here today?
It was presented, everything I've talked about today has been presented in previous hearing at the advisory agency. In fact, the ability to use the relocation benefit dollars towards their down payment was a request by Ms. Harper. I thought it was a great idea, and so we immediately complied at
Who's
that
Ms.
point.
Hartford?
The advisory agency
Advisory
deputy
agency,
who handled the
okay.
hearing.
And so it's not new, it's not something you're presenting
sir.
today?
Okay. Seeing no other questions from my colleagues, thank you, sir.
Thank you.
And we'll proceed with the speaking cards. Legally, the appellant is offered time to express their reasons, and given more than 2 minutes. The clock here, assuming we have quite a few cards, and there's not many more items that, other items that we need to attend to, we'll have about 1 minute per speaker on this item. So we have with us Stephanie Hafner, and then Laura Gross, and then Laura Joseph. Good afternoon, ma'am.
Good afternoon, Mr. Chairman and members of the committee. I'm passing out to you now comments submitted by Neighborhood Legal Services regarding the appeal, the developer's appeal. My name's Stephanie Hafner. I'm an attorney with Neighborhood Legal Services. The tenants at 1511 Magnolia live in a rare mixed-income rent-stabilized apartment complex in Sherman Oaks. As you know, this is the developer's second attempt to subdivide. In his first attempt, he did not give notice to tenants of their right to participate in the public process. And he gave tenants misleading relocation information, telling them that the amounts of relocation assistance would be $2,000 to $5,000 instead of the $17,000 that was authorized at that time. He issued Ellis eviction notices to close the building where the most active tenants lived. And at the public hearing where the advisory agency announced its decision to deny the application, he whipped out his cell phone and walked past a group of tenants and said into the phone, "We lost the hearing. Prepare the Ellis eviction notices." This is the type of actor who is in front of you. May I proceed?
Can you just summarize?
Yes. 6 months later, you have the new application that is in front of you. The planning department, again, we think properly denied the application. There is no dispute that the developer's manager distributed that notice. That notice is included as Exhibit 1 to our letter. And it says, "To all residents of Grand Villas, it's been brought to my attention by 2 different residents that Condo Conversion is back on. Not so." And that is effectively an anti-notice. The Subdivision Map Act requires the developer to let tenants know of their right to participate in the public process.
Thank you, ma'am. Thank you very much. Our next speaker, there he goes. And then we have Mara Joseph, and then Denise Hamilton. Good afternoon, sir.
Good afternoon. Larry Gross, Coalition for Economic Survival. We urge that you uphold the denial. If there was ever a slam dunk, this is it. The vacancy rate here is below 5%, and losing 104 RSO units will have a cumulative impact. Thus, we urge denial on that point alone. The owner has consistently failed to comply with tenant notification requirements. He failed to submit an adequate tenant relocation plan as required. In addition, the overwhelming majority of the tenants have stated their unwillingness or that they're unable to purchase the condos there. Tenants have continuously stated, hearing after hearing, about how this owner has lied to them, attempted to intimidate them, harassed them, threatened to evict them, and failed to provide tenants who have already moved relocation assistance. These actions should not be rewarded. Thus, we urge that you uphold the decision to deny this condo conversion. Thank you.
Thank you, Mr. Gross. And just for the record, I do have Councilman Zine here with me. He's just eating right behind the pillar, but he's listening and participating. Just for the record, that we do have a quorum. There you go, see? Okay, Marla Joseph, Denise Hamilton, and Jane Arias. Good afternoon.
Hi, my name is Marla Joseph, and I reside at 15101 Magnolia Boulevard.
Can you read into speak into the microphone, please? We can hear you better.
My name is Marla Joseph, and I reside at 15101 Magnolia Boulevard in Sherman Oaks. Handing out some packets is just the documentation that basically it revolves around the negative cumulative effect to the tenants. It's the willing and able statement. 66% of the tenants said they are not capable of purchasing the unit at the price that was listed on the city application. Secondly, it's just some data gathered on RSO units lost, meaning affordable housing is an issue here in Los Angeles that we all know, and there's documents from the city planning department of all the cases that were submitted applications. And then thirdly, the number of seniors, disabled, and children in the building that will be displaced by this application. And lastly, I want you to please revisit the mitigated negative declaration. There's a school within a quarter mile of the complex, and there is lead and asbestos.
Thank you very much.
Thank you.
Denise Hamilton, Jane Arias, and Barbara Saggett.
Hello, my name is Denise Hamilton. I am a resident in this building that we're discussing. As of this January, I will have been a resident for 14 years. During that time, I have seen 4 business owners and 7 building managers. I've seen quite a bit. The most common constant has been the tenants. When I moved in, the person who lived next door to me, Hilda and her husband, lived there for 22 years. Doris, who lived below me, was living there for 27 years. The couple that lived across from me lived there 18 years. The constant has been that there has been a community of people sprinkled throughout this large building that really have taken care of each other and have worked towards each other. Now, my mother is elderly, and when I moved her in there, I realized that there is a provision that is not going to force me to move out of this building. However, I have lived through a conversion in that building already where they tore down the building to put in copper pipes, put in others. I don't want to live there while there is a conversion. My mother is 91. I should not have to do that. That's number one. Number two, it's very important for you to realize that these are people who did not go out and live beyond their means and buy a house that they couldn't afford. Okay?
Thank you, Ms. Hamilton.
Thank you very much.
Jane Arias, Barbara Saggett, and then we have John Pentazes.
Good afternoon, members. Gene Arias, I'm at 1501 Magnolia Boulevard, apartment E7, and I'm one of the occupants that's been there about 30 years. But most importantly, about 4 years ago, I joined the National Guard. And the reason I did, I belonged to the state emergency procurement team, fought the fires in 2007, 2008. We saved, our unit with the National Guard along with the emergency team saved thousands of homes. And all I'm asking you to do is help me save mine. Thank you very much.
Thank you, sir. Barbara Saggett, John Pentazes, and Ross Thorne. And last speaker will be Brooke Harker. These are the cards I have. Good afternoon, ma'am.
Good afternoon. My name is Barbara Saggett. My husband and I, who are both seniors, have been living in our home for almost 21 years. There are many seniors in our complex and some are disabled. I'm still working as a social worker and work with the elderly and handicapped people. My husband is a special ed teacher. We're able to continue working and serving the community because we live in an apartment that is affordable and convenient to the areas where we work. Conversion to a condo that will be priced way out of our reach will force us to move out of the community and force us into retirement and relocation years before we need to or want to. Thank you.
Thank you, ma'am. John Pantesis, Ross Thorne, and Brooke Harker. Good afternoon, sir.
My name is John Pantesis, and we've been in this campus for the past 25 years. I'm a disabled Vietnam vet, and my son also is in the military right now fighting for the freedom of this country to save all of us here. And he's coming home soon, and I wanted to know, who's going to tell him why you're fighting? These people that you're protecting, they're kicking you out of your own home. This is the only home he knows. And I want you to take it under consideration. Is this the land of the greed or the land of the free? I'd like to take that under consideration. Because like I said, I'm a Vietnam vet, disabled Vietnam vet. I will be there for 25 years. And I thought I was fighting for my freedom and the right to live where I've been there for 25 years. And I would like to add one more thing. Who will tell my son, as we speak right now, he's fighting to put a security blanket on the gentleman that previously talked about his greed? Is he going to tell him, welcome home, son, welcome home, thank you for fighting for us, but I'm sorry, while you were fighting, I kicked you out of your home. Is this the land of the free or the land of the greed? Thank you so much.
Thank you, sir. Ross Thorne and Brooke Harker.
My name is Ross Thorne. I've been living at the so-called, absurdly called Grand Vias for 14 years. People moved into this place mostly because the rents were reasonable and pets were allowed, cats and dogs. We have surveyed 23 apartment buildings within 6 miles by car from these so-called Grand Vias, which will accept dogs and or cats. 21 will accept both, and 2 will accept cats only. We've compared them to what we have at the so-called Grand Vias. 75% of the apartments at our complex are 2-bedroom units, 78 out of the 104 units. And we've compared them to what's available in the dog and cat complexes that I've earlier mentioned. Of the surveyed units, the average monthly rent is $1,662. Average square feet, 1,007.
Thank you, sir. Thank you. Ms. King, please finish.
Okay, I'll summarize this. If we were forced to move and go within 6 miles to these units, we pay 45% more rent, and we can't afford that, and we'd have 1/3 less space. Thank you.
Thank you very much, sir. That concludes the public hearing. Did you submit a card, ma'am? Well, please come on up. I'm sorry.
Hi, good afternoon. My name is Brooke Harker. I live at 15101 apartment B1 with my sister. I've lived there for 6 years. She's been there for 8 years. I agree with Denise when she says that everyone takes care of each other there. We have from babies to people in their 90s, and it is a family and it is a community. And I was there last year when the owner said to Rose, "You'll never have to leave." And she looked at me and she said, "I don't believe him." A man that would say, prepare the Ellis Acts in front of her family, the people that help her if she's not feeling well, or help her get groceries, or whatever it is. You can get rid of all of the people and leave one 90-year-old woman by herself. When she doesn't have any family? What good does that do? The people in the complex are full of hardworking citizens in all areas. I work with children, and I have a job interview for my 3rd job today. I work very hard just to pay the bills that I have, and the economy hasn't been so good. So I ask that you save our homes. Thank you.
Thank you, Ms. Margaret. Okay, I believe that does conclude the public hearing. Any Any questions or comments from my colleagues on this or any motions?
Mr. Chair, I find it interesting that the tenants that have testified have lived there for such a long period of time. And when you start to age, what happens is you lose your driver's license. Now you feel abandoned, and your family moves away. Now you feel isolated. And what we find in this particular situation is a village within the neighborhood where people take care of each other. So I find that the folks that are living there have really set up the environment to help each other and to care for each other. And I think it's a callous society oftentimes that we live in, and we forget about the human aspect. And I've got a lot of compassion for seniors. And to have the number that was given, 8 or 9, those are people who've really done a lot, I believe, in society. And it would be unconscionable for us to displace those and the other folks that live in that particular unit who seem to be very happy, at least the ones that have testified. And I know there's a lot of units in the city. I don't know how many have the longevity of this particular building with the number of tenants that seem to be very pleased with it. So I would make a motion, Mr. Chair, to support the staff report on this particular project.
Okay. Thank you, Councilman Zine. I want to just, for the record, though, also, I support what you're saying wholeheartedly, Councilman Zine, but as I look at the report from the staff, the vacancy rate of the pending units of property is located is less than 5%. The fact that the staff indicates that the vacancy rate within the county plan of the project is located as 3.8%, which is less than the 5% threshold. When I look at the vacancy rate within the plan area, will be further reduced if the proposed conversion is allowed as a harmful rental and will be removed from the rental housing market. So there are that's some of these under that principle. Then when you look at the non-compliance with the 60-day notification required by section 66452.9 of the California Government Code, Subdivision Map Act, that too is a big concern and a reason why I would support denial of the appeal. Councilman Rizal, any comments or any observations?
It's my sentiment as well. However, I do want to make clear that normally we ask for guidance from the representative from this area, and there is no, I just want to state that there is no representative who currently represents this area, but just want to put that out there for the record.
Thank you. Thank you for that. That's right there. I think it's run off time, right? So, that being said, the motion would be to deny the appeal. We have a second? Second. Councilman Rizal?
Yes.
Okay. So that would be the action of this committee, deny the appeal. Okay, let me just go through the agenda really fast. But some of you are here for certain items. And I just learned that we have an LAPD officer who should be on the field in the room, so we're going to try to move on that item.
Speaker cards on 11, and that's been continued.
Okay. And 1, A, B, and C will be special, so that'll be on the agenda, as well as D. Item number 2, Saggett College. On 2, we're going to refer to the planning department with assistance on the city attorney. Number 3, we'll call a special. I understand that's where we might have our officer as well on that item. 4. Yeah. Okay. 4, we'll call a special, seeing speaker cards. Put on vibrate. So 4 does have speaker cards on it. 5. Still no cards. We can. We'll have to be calling 5 special as well. 6. we'll call special. 7, 8, 9 will continue to October 13th in this committee. Okay. Number 10 we just reviewed. 11 will continue 90 days. And there are several people on item 11.
Well, for further clarification on number 11, we got specific dates from the applicant contained to January 12, 2010 in Plum, and in council January 27, 2010.
So quite a few cards here on number 11. I just want to repeat those dates. Item number 11 will be continued in this committee on January 12th, 2010. That's next year. And then council January 27th. So that's item number 11. So whenever you fill out cards for 11, this will be continued. So you're welcome to stay, or you can beat the traffic, one or the other. All right. And 12, so no speaker cards on that. We'll be continuing that to October 6th in council October 20th. And we don't have a director's report today. We do not. So, and the item of the officer we have is that item number 8? Which? Number 3? Okay, item number 3. We don't have any speaker cards on that one, but we do have an officer here. And let's get the staff to report on item number 3. The staff here? Just a minute, sir. Staff on item number 3?
It's a hardship, medical marijuana hardship exemption request, Councilman.
And we have the officer here for that one?
Right.
Okay. I do have some folks on this, and I'm sorry. Okay, so Roberto, tell us what number 3 is one more time.
Item 3, council members, it's an application filed by Kendra Rhodes. It's a medical marijuana hardship exemption request for King Collective Caregivers in CD8.
Okay, do we have staff here for that one? Okay, let's let our officer come on up. Good afternoon, sir.
Good afternoon. I was asked to speak before the council here just to touch upon the law enforcement.
Sure. Could you give us your name and...
Oh, sorry about that. Sonny Sasajima, S-A-S-A-J-I-M-A. I'm the senior lead officer for the Leimert Park area, Southwest Division. Leimert Park community. All right. I was asked to speak on behalf of the community as far as the law enforcement perspective. I just wanted to bring out some numbers here. Over the last 1 year period from August 1st to August 1st of 2008 to August 31st of 2009, I was able to pull up a number of 24 arrests for a section.
You put the microphone.
Got it. I was able to pull up 24 arrests for a little section of the block that's bordered by Crenshaw on the west, MLK on the north, McClung on the east, and there's an alley, an east-west alley on the south side where this dispensary is located at. In that 1 year snapshot, I was able to pull up 24 arrests, and of the 24 arrests, 5 were for marijuana sales, 2 were for possession of marijuana, 3 were for drinking in public, and 1 for possession of a gun, just to name a few. A lot of concerns have been raised during several block clubs that I've attended to, several community meetings that I've attended with the location of the dispensary, because it is a main thoroughfare for children of a local middle school to take when they go home. They use that sidewalk on the south side of King, which is directly in front of the dispensary, as well as the alley to the south, which is directly to the rear of the location. And
So the dispensary is right in front of the school?
it's not right in front of the school. It's actually along the path that a large majority of the kids take to get home. That corner itself, Crenshaw and King, has actually been kind of a hot spot for various activity. There's a lot of activity with bus stops. There's a lot of people just hanging out, drinking, and there is that constant smell of marijuana kind of in the air. While from the police perspective, we've been trying to keep tabs on the location, speaking to property owners with regards to kind of toning down the loitering, trying to enforce as much as we can with the resources that we have. It's been a constant problem just because of the high activity, pedestrian and vehicle traffic in the area.
Can you, trying to phrase this right, can you distinguish which activity emanates from the dispensary versus those who would have been there even if the dispensary wasn't there?
Well, the dispensary's been there for, I believe, for the last 5 weeks, so it's hard to discern that whether or not the folks are there for the dispensary itself. It's just my take on it is that with the high narcotic activity, as far as marijuana goes in that area, it's going to be hard to discern whether the marijuana is there legitimately for the medical purposes or if it's for illegal purposes, which I've been coming across in the past. There are a handful of folks that are on parole or probation for marijuana sales that I've personally arrested that still hang out in that location, in that specific alley to this day. And they're hanging out there for a reason. And the reason I kind of bring that up is because it's going to come to that point where when we stop folks in possession of marijuana, it's going to be hard to discern who's got it legally and who doesn't have it legally.
Okay. Thank you, sir. Any questions, my colleagues?
A couple, Mr. Chair, regarding the school. What age at that school? Is it a junior high, a middle school, or elementary, or what?
It is actually a middle school. And this school year, they actually opened up a charter high school on the back part of that campus as well.
So middle school and a high school?
Middle school and high school, correct.
And are there any other dispensaries in that immediate vicinity of Crenshaw and MLK?
Not in that immediate vicinity. I believe there's one further south off of 48th. I'm sorry, a little further south along 48th and Crenshaw, I believe.
And what about reported crimes at the facility itself? Do you have any reports of?
No, I wasn't able to find any reports for the actual facility, the address itself. However, there are numerous police reports for robbery, for just theft from persons that actually occur at in that general vicinity.
And what other types of businesses are located around there in that vicinity?
To the east, there is a nail salon. To the west, to the immediate west, there's a M&M's restaurant. One west of the M&M's restaurant is a Louisiana Fried Chicken. To the south of that, I believe there's a clothing store and a convenience store.
So those locations generally would not attract issues regarding marijuana or possession of a gun, drinking in public. The other establishments would not attract that type of activity.
I would say that, yes.
Okay, thank you.
Thank you, officer. Thank you for your time and your hard work. Okay. I do know we have others. Dennis Rodriguez, would you like to speak last or first? It's up to you, sir.
If I may, I'd like to speak last.
Okay.
Yep.
So we'll move. So let's hear from Kedron Rhodes, and then Johnny Williams, and then Damon Goodman. And then we'll hear from Mr. Rodriguez. Good afternoon, ma'am.
Good afternoon. I am Kedron Rhodes. I am the dispensary owner. And I just want to kind of comment, give you a little bit about my background. I've been was a probation officer for 15 years. I retired, and I opened up the dispensary from my mother-in-law having cancer and not wanting to purchase it on the street. And the cost of marijuana medicine, as far as the Marinol, it was pretty expensive, like $900. So a lot of this led me to doing history and wanting to open up a dispensary. But just to speak on what the officer has said before, because he's came to visit me, I have shown him the packaging for the marijuana. I have also offered to let him come and visit the dispensary along with the Building Improvement Development Committee. Buildings, well, they're called BID, I don't know, but also he said there was 24 arrests from August of last year to August of this year. None of those arrests has been anywhere within the vicinity of my dispensary. I have opened for 5 weeks. Within that 5 weeks, I have cleared the alleyway. No one hangs out in the back. Even people from this committee can verify that, has said that to me. And pretty much I'm basically trying to better the area. We haven't had any type of crimes, and that's what I want to know within the 5 weeks. How many people have been arrested based on my dispensary? No one's been arrested based on that. And even when I'm saying there's a lot of drug trafficking and all that, although there is a lot of drug trafficking in that area, it doesn't mean that it came from my dispensary. I am not a drug dealer. I don't even participate in anything like that. And I also have records of everyone who comes to my dispensary that they can definitely see it and compare it to their arrest record and see if any of these people that have been arrested are from my dispensary. That's why I have records. So with that, I wish he would answer that question about how many people have been arrested because of my dispensary.
How long have you been open?
For 5 weeks.
5 weeks.
Yes.
And you applied for a hardship exemption. Did someone tell you that you have the right to open with a hardship exemption?
Yes.
Who told you that?
My attorney.
Your attorney?
Yes.
Anybody from the city government, city clerk's office, planning department mentioned to you that you could open with a hardship exemption?
I haven't had anything. The only thing I got from the city was the letter about this meeting today.
Okay. Can you tell your attorney that he should probably go on the LA City website?
Yes.
And I believe it says there, if my city attorneys could correct me, that just because you apply for a hardship exemption does not mean you can't have the right to open your dispensary.
Yeah.
So your attorney should go read the website and get the regulations we've set forth about hardship exemptions.
And for my awareness of that, he explained to me that that's just an opinion, that wasn't a law. So.
Okay. That's fine.
Councilman?
You admit that there's drug activity in the area?
That
not associated with your establishment?
Not associated with me at all. And it's
but there is drug activity in the area?
I'm quite sure.
Okay.
I mean, this is what the officer explained to me. But if there's drug trafficking going on behind my building, I have cleared all that, and there's no one in that area over there.
Was that happening before you opened the establishment?
Was people behind the back? Yes, it was. A lot of people, and I cleared it.
And you now have this dispensary because of your dad?
No, because of my mother-in-law.
Your mother-in-law?
Yes.
Okay, who needs that under a doctor's prescription?
Who needed it. She passed away, unfortunately.
Okay, our condolences on the passing of your loved one.
Thank you.
Where do you get your marijuana from?
We have dispensers that dispenses out. As a dispensary that dispenses out to dispensaries. So that is located in Woodland Hills, and that's also a list that's provided to me from my lawyer.
So you don't purchase, you don't grow, you purchase from...
I don't grow, and I don't purchase from the street.
You purchase from someone who distributes?
From a distributor,
A distributor?
Yes, sir.
Okay. You know you are permitted to grow under the Compassionate Use Act for
I'm aware of that,
loved
yes.
ones?
I'm aware of that.
You just choose to purchase it?
I choose not to.
Okay, and other than the marijuana, what other products do you sell?
The marijuana, that's pretty much it. Lighters.
Do you sell any food products?
No.
So just the marijuana itself?
Yes.
Any other items to go along with that?
No. Okay. With my tobacco license, I'm allowed to sell lighters and other type of products that's associated with it, like wraps and stuff like that, but no.
Okay, so no edibles then?
I'm sorry.
No edibles, no food?
No.
Okay, thank you.
Yeah, I just want to state again, whether this area is free of crime or not is irrelevant.
It is.
The fact of the matter is that you have no right to open your dispensary. You should advise your attorney that when we are interpreting our regulations and laws, we do give advice. We do say how we should interpret those rules and regulations. And they're very clear in black and white that just because you apply for a hardship exemption does not mean you could open. And again, for the record and for everyone to hear us, these dispensaries should not be opening. So to me, whether we have the highest crime rate around this dispensary or if it's the safest place in the city of Los Angeles, this dispensary should not be open.
And I respect that.
So
I respect that.
And again, the date was November 14th, 07.
I'm aware of that.
And so all of these different applications are coming before us as a hardship exemption and trying to tell us why you could not open before November 14th. And I haven't heard a reason yet.
Well, honestly, I would have opened before then, but that's the same year and the same month that my mother-in-law passed away. And that wasn't even, after I did research on it and found out more information on it, is when I decided to open.
I understand.
That's the best way I can answer that question. I'm sorry.
And I respect that. Thank you.
Thank you.
Okay. Our next speaker, Johnny Raines.
Good afternoon. My name is Johnny Raines. My address is 4115 South Norton. Live about 2 blocks from where this establishment is. You had asked a question earlier about the proximity of the middle school. The middle school is 2 blocks east of this dispensary, and hundreds of students pass both in front of it and behind it in the alley every day. I escort a lot of these kids back and forth from school doing a safe passage that's community-based. One of my other concerns is that there was no kind of community notification that this place was even going to come into existence. We just happened to find out that it was there. If a liquor store or someone selling beer and wine comes in the community, I believe there is some process of notifying the community that this sale is going to go on. None of this occurred. There's an additional dispensary within 3/4 of a mile just down Crenshaw of this place, of this new dispensary. And that brings my last question is, how is it determined whether or not these are actually needed? That's my question. Okay. There doesn't seem to be any way that the need is determined. Thank you.
Thank you, sir. William Goodman?
Good afternoon, Mr. Chairman, council members. My name is Damian Goodman. I'm the co-chair of the Neighborhood Council, and unfortunately I can't speak on a position because, like Johnny just said, we just recently found out about it. But I would say, given our Neighborhood Council's history in trying to combat the regulated substances, the chances of us supporting this request for a hardship exemption is somewhere in the realm of not now and not ever. As is stated by the officer, this is a chronically bad location. Whether her improvements, which I frequent this location, given that it's the location of a bus stop that I used to get here today, and saw the vending of illegal, or I should say, jeans that likely fell off of a truck, coupled with the loitering individuals who were selling incense and whatever else products. This is not the place to open a dispensary. I also need to urge this council to adopt some type of ordinance. You can amend it later. We need to get adequate notification of these processes. Finally, forgive me, because in addition to the middle school, which is 2 blocks away, literally 3 doors down is a daycare. It's at 3548 MLK Bright Future Daycare. Two blocks away on the corner of 41st and Bronson is another daycare, Stewart Daycare. The address is 3443 41st Street. This is not a location for this dispensary to be open, and it opened illegally, and I'm glad the council member pointed that out to the applicant. We had attempted to in the Business Improvement District meetings before. Thank you, Mr. Chairman.
Thank you, sir. I am listening. I'm doing a few things at one time, but I am listening. Okay, Dennis Rodriguez, our last speaker.
Good afternoon. I'm Dennis Rodriguez with Councilman Bernard Park's office. Just want to state for the record that we are opposed to the hardship exemption being granted. We've also submitted a letter which explains our position, which is included in your packet. Again, we're requesting this denial of this hardship exemption today.
Thank you, sir.
Thank you.
Colleagues, any comments or actions?
Move to deny the hardship exemption application.
Okay, a second.
I concur with that. I just wanted to acknowledge the the two gentlemen that came from the community, take your time to come down here to testify on this matter. It's important to us to hear from the community members and the impact on your neighborhood. So I want to acknowledge and appreciate your coming down and testifying. Thank you. And I do support the denial.
And I support the denial based on the fact that the applicant, in my mind, failed to register with the city clerk pursuant to Section 3 of the Ordinance, which is not to restrict that a hardship exists from provisions of the SEO. That'll be the reason for my action as well. So,
Mr. Chair, I have one question. How long does the establishment have to close down once this is denied? Has that been, direction been given on that?
Madam Attorney?
Once they're denied, when do they need to close?
Jerry Burge, City Attorney's Office, they should close immediately.
And there'll be a follow-up with building and safety?
Excuse me, Building and Safety has the enforcement authority, and so does the Criminal Division of the City Attorney's Office.
Okay, I would direct that the Building and Safety Department take immediate action on this, along with the City Attorney's Office. So cease operations. Mr. Bush from the City Building and Safety Department.
Good afternoon, Frank Bush, the Assistant Chief of the Code Enforcement Bureau, Department of Building and Safety. As soon as this moves to City Council, is denied by City Council, we will conduct an inspection. If they are still open, we will move the case to the City Attorney for further enforcement.
You bring up a very interesting point, Mr. Zine, because I've been told that once those requests from Building and Safety get to the City Attorney's Office, then none have been filed. Is there a reason for that?
Again, for the record, Jerry Burge, as you know, I'm in the Civil Division of the City Attorney's Office and have no responsibility for the Criminal Division. I think the Criminal Division may be here and they can answer that question, or we can get an answer for you later.
Is there someone here from the Criminal Division of the City Attorney's Office?
Okay. 5, 6, 7, 8.
Good afternoon. My name is Cherie Sanders. I'm the neighborhood prosecutor for the Crenshaw Area Project. I can say if this does come to me, I will be filing the case, so there's no issue with that at all. I can't speak for the entire division, but I can say that if I do get this case, that it will be filed and there won't be any issue.
And you're from where?
I'm the neighborhood prosecutor actually assigned to this area.
Yeah, well, there seems to be a bottleneck in some place because we've been request 9 cases in our district that we've asked about that we've denied a hardship exemption, and nothing seems to be moving from the City Attorney's Office for filing.
I can take that back to the office and share that information. I'm just saying for this particular one, that's not going to be an issue.
Thank you, we appreciate it. And if we could have a report back from thank you very much. We could have a report back from our city attorneys that staff this committee on all the hardship exemptions that this committee have denied. How many have actually been filed or pursued? Thank you.
Can we get to a point where we know whether the facility has been closed?
Again, I will certainly take that back to and ask the Criminal Division. They can come here and report. I believe that many have closed on their own as a result of actions of denial of hardship exemptions. I don't have a number for you, but I believe that's true.
I asked Mr. Bush.
I'm not just asking, who could confirm that the establishment has been closed, Madam Attorney? Who would be in the position? Building and Safety?
Building and Safety can do that.
Could you give us at least a profile or number of facilities that have been closed since the actions that have been taken by the city?
Again, Frank Bush. I'm aware of 82 that were denied by council. We conducted investigations on all those. 52 of them, I can report to you, had either did not open or have closed since that has happened. With the exception, we just had a report on one of those 52 that has opened back up. We've confirmed that today. We will be moving that to the city attorney's office. 30 of the 82 have been investigation conducted, and it has been submitted to the city city attorney for further enforcement.
So that's the bottleneck you're referring to, Councilman Rosario? Yes. Okay.
There appears to be some logjam someplace where those that we've asked to be looked into they stop at the city attorney's office and not further prosecuted, and that needs to be looked upon. So we need to get a report back on this whole process as to those that we've denied the hardship exemptions, which have actually closed. Have there been prosecution? Do they refuse to close? We need a status report on that. There are community members who are really concerned that even after we took this action, there may be some dispensaries that are refusing to abide by the law, and we are not doing our job in prosecuting those that are operating illegally.
Councilors, that's something that probably would be better put on a future agenda, since enforcement is not something on this agenda.
I would also ask that the Los Angeles Police Department attend that meeting, and there the enforcement branch, if building and safety can't get compliance and the city attorney's office prosecutes, they have the authority to make arrests if there's not a compliance. So I think they should be part of that when we do schedule that hearing.
Right. I'll consult with the city attorney, but maybe the question I would have is, do we have that in closed session or open session? And that's something we should think about, but knowing the litigious nature of this process.
Yes, we can give you a recommendation. Obviously, that would be with your civil attorneys representing the municipal corporation, and the criminal attorneys can come with a report to you.
Okay.
Thank you, Mr. Chair. Thank you very much. And, you know, there seems to be a breakdown in this process, because before we deleted the hardship exemption from our interim control ordinance, we were concerned that the city attorney's office wasn't prosecuting those facilities because there had been no finality to the city's adoption of a final ordinance. So the city attorney refused to file any cases to prosecute those individuals who were operating illegally. I'm further concerned now that even after we've acted as a council on those hardship exemptions, and we've done our best job to start cracking at that huge mountain of applications that we have, we still find that the city attorney does not prosecute those facilities. And so we need
Councilman,
to...
I can tell you that the city has received a lawsuit challenging the ICOs, and that is a public record, and that is something that we could discuss further in closed session. Also, I will tell you that our consistent advice for the past 2 years has been to this body as well as to the city council that the best thing you can do for enforcement is to adopt a permanent regulation. That has been our advice for 2 years. That continues to be our advice. You have that before you today. And again, our best recommendation is to adopt a permanent ordinance that can be enforced.
Okay, but we at least have to be clear about what path we're taking. If the advice is going to be adopt your ordinance and that will take care of all these illegal dispensaries, fine, but we are acting under the pretense that we are denying hardship exemptions and we're not even going to prosecute. We have to be very clear and transparent about what we're actually doing here. I'm not going to urge constituents in my community to keep bringing forward these dispensaries to our attention and deny their hardship exemption if it's just all a horse and pony show here, if we're not actually going to prosecute. And, you know, these dispensaries continue to operate knowing full well that we're not going to prosecute. We just have to be very clear what is our direction. Are we going to adopt the permanent ordinance, and that is our goal and plan to deal with these illegal dispensaries? Fine, let's do that. But let's not continue to have this dog and pony show here without any action at the end.
If I may add, I don't believe that, and I know the city attorney's advice is there's been some conflict between the direction and what we're trying to establish with the ordinance. That does not prevent the Drug Enforcement Administration or the Los Angeles Police Department or the Los Angeles District Attorney or the Sheriff of Los Angeles County to take enforcement action on those locations that aren't complying with the law. And if they want to file a lawsuit, they can file a lawsuit, but the DEA ordinance under federal law says they can't operate at all. So if they want to ignore our regulations, they want to ignore the denial, then we can ask the DEA to take those particular establishments and shut them down because they're not complying with the law. If they want to play that, we'll play that with them. Otherwise, we'll get compliance through the ordinance. But in the meantime, when we have these hearings and denial is given and they don't want to shut down, as Mr. Bush has said from Building Safety, those 30 locations that continue to operate, they are absolutely in violation. And if the city attorney doesn't want to take action, then I would say we have the DEA take action and give them those locations that don't want to comply after there's been a fair hearing and it's been denied.
Okay. I'm going to hold my tongue. There's a reason why it's taken so long. We were trying our best to work with the advocates. We were trying to do something humane for those who are suffering from cancer. We weren't getting a direction from the city attorney initially. And as far as I checked the last time, we were the policymakers. Yes, we do follow the advice. This has been the balancing act, and if we could have reached that point 2 years ago, we would have passed that ordinance. We never got there. So we're here now, so let's make the best of what we have in front of us and move on. So that being said, let me just go through.
Let me just emphasize one more point. I want to utilize the resources of law enforcement, including the DEA, only on those locations that are in violation after a fair hearing is given and they are ordered to close, in those particular locations, not the other establishments that we're dealing with.
Okay. Colleagues, there are a few minutes to spend some of the items that I'm jumping around out of courtesy to some of the seniors that were on the first item in the LAPD. But my understanding is that we can move on consent items 4, 5, 6, and 7, and 8. We can move on consent with the following amendment. And the amendment to item 8 would be modify hardship exemption to remove the staircase request and to only allow replacement of windows and siding that matches original construction materials. So with that amendment number 8, we can move those items for those of you who are here for those items. So can we get a second on that? Second. Okay, and move those items. Now, Roberto, I guess this brings us back to item number 1.
Yes, Councilman. And item number 3, you denied the application, correct?
Or we...
Yes. Yes, okay.
Is that the, just for the clerk, that you'd like to go to council on number 3 is the denial? Because I think you made a motion, Councilman Resign, that the department be directed to report back. The city attorney and the Department of Building Safety, is that part of your request?
And the police department.
And the police department. Is that the second?
Yes.
All right, thank you.
Yes. On item number 4, I got ahead of myself. There are cards on item number 4. So we'll call for a special evacuation of those on item number 4. So let's go back to item number 1. Number 1.
You don't want to consider item 4?
No, we do have cards on 4, and let's just go to item number 1, get to that, and we'll get to 4.
Item 1, Councilman, is a motion by Councilman Sine, seconded by Ms. Hahn, yourself, and others. It's requesting a written report from the city attorney as to interpretation of the California Health and Safety Code and various law cases as it relates to the medical marijuana issue.
Okay, then we have items A, B, C, and D. We can all take them together, correct?
Right.
Do you want to read each one? Or
sure. Item, that was 1A. 1B, Councilman, is a draft ordinance from the city attorney. This is the third version of the ordinance to regulate medical marijuana in the city. 1C is a communication from yourself, and it has to do with a proposed medical marijuana ordinance, which I believe the city attorney has already incorporated into 1B. And then 1D is a status report from city planning as to the mapping and various land use issues.
Okay. If, in terms of presentation, we can have the city attorney's office just give us a quick recap on the third version that tended to collapse the two previous ordinances into this third version. So you can give us a recap on where we're at and what you feel is most important for us to review. Yeah. That's...
Good afternoon, Heather Aubrey, City Attorney's Office. The third revised draft ordinance was presented to you at last week's meeting, and the most critical revisions to that ordinance were discussed at that time. I have before me the ordinance itself, not the report accompanying it, but going through it, I would certainly say that one of the most important provisions is the pre-registration requirement, which requires that certain requirements be pre-inspected and verified by the Department of Building and Safety to ensure compliance prior to the opening of these establishments. Those are what are referred to as the development standards. There are other additions and changes to the ordinance which I think are particularly important, including the maintenance of records provision, having additional documentation requirements, the existing medical marijuana dispensaries provision relating to the period by which the dispensaries must comply, with the exception of those that registered under the ICO and were operating in compliance with the ICO. And the violation and enforcement section, as well as the compliance with this article in state law section, are also new provisions that have been added to the ordinance. And if you have any questions, I'll be happy to entertain them.
Okay. First ask my colleagues, have questions or comments on this? Any questions? Well, I wanted to hear from the city attorney, give us a recap of what were the most prominent changes that reflects a mutual understanding of a path forward. And I believe that's what was highlighted. Next, what we can do is, since we've had a lot of public hearing on this, colleagues will ask for our preference. We can have 5 minutes on each side or 10 minutes on each side, for or against. Do you have a preference?
How many cards are there?
There's quite a few cards, actually. So, we can do 1 minute per speaker. Let's do that. Let's go there. Okay. We have Don Duncan, Alex Campbell, Oliver Simmons, and Barry Kramer. And you're welcome to follow along so that we can move this quicker. Good afternoon, Mr. Duncan.
Good afternoon, committee members. My name is Don Duncan, a resident of Los Angeles and the California Director of Americans for Safe Access. I'm responding today to the 11th hour analysis that's been provided by the City Attorney's Office regarding the case law surrounding medical cannabis collectors and cooperatives. And that analysis, in a very brief reading, is deceptive and misstates the law. Most importantly, what we see in the analysis is that the report consistently confuses a primary caregiver with a collective or a cooperative, and these are not the same things. A collective or a cooperative, which is legally organized under Section 775 of SB 420, may be comprised of patients and caregivers, but it itself is not a primary caregiver. The report uses this confusion to muddy the waters and suggest a whole range of things collectives and cooperatives cannot do. One of these is sell medicine, and that is simply not the case. I've sent you a lot of writing about this in advance. I hope you'll review that. I also want to emphasize for you that there's a substantial amount of improvement that we need in moving forward with the alternative version of the ordinance. So I hope you will consider the track record, frankly, of the City Attorney's analysis when evaluating this report.
Thank you, sir.
Handout for the committee. My name is Alex Campbell. I'm a resident of Los Angeles for 23 years. I've been involved in medical cannabis here in Los Angeles for the past few years. I made a documentary about it entitled Super High Me. I have a document that I just gave to you for your attention. You were asking what the city attorney is up to. They are holding a luncheon next week to eradicate medical marijuana dispensaries in the city of Los Angeles. You can refer to the document that I just handed to you right there. Thank you very much.
Thank you, sir. Yes.
Excuse me, sir. Interestingly, I was flipping the channels this weekend and I came across your documentary and I watched the full 2 hours. It was 2 hours, right? Yeah.
92 minutes.
Yes, and briefly stated, what was your conclusion after this documentary? What do you think was the overall message of the documentary?
Of my documentary?
Yes.
I wanted to make people laugh.
Okay. And did you have, having somebody get high for 30 days consistently, every day, were there any effects on this person?
There were no negative medical effects. We had him supervised by the finest medical doctors in the city of Los Angeles, both psychiatric and physical.
And what was his medical condition?
His medical condition, I'm not him, I'm not his doctor. I don't think that's proper for me to disclose.
Okay, so...
But it is a medical condition covered by...
But there was a medical condition?
Yes, he was a legally qualified California patient. Yes, that is correct.
Okay, thank you.
Okay. Our summaries by Kramer and then Sarah Armstrong.
Good afternoon. Thank you for hearing from me. My name is Oliver Summers. I'm a resident of Los Angeles, and I ran a pre-ICO collective called 420 Compassion Center. In 2007, I was closed to the DEA intimidation landlord letter, and since then, I have not been operating because you guys asked me not to, and I've been waiting for you to act on my hardship application in all that time. But I digress. I'm very disappointed with this committee in the past 2 years for the lack of action that has happened. The amount of misinformation that is coming out of the city attorney's office, and quite frankly, sir, yours as well, of how cannabis is run in this city is really, really horrible, I have to admit. The entire country is watching Los Angeles right now. Medical cannabis is going across every state, and it's rising faster and faster. Every country, every city, every state is watching us right now on how we handle this. Let us lead progressively, please. I encourage you to work with us in the cannabis community in drafting ordinances. We are the ones who are here every day dealing with this. These unreasonable things that you guys are asking are very hard. I, for one, know I can't grow in Los Angeles. Where am I supposed to get my medicine that way? But thank you very much for your time.
Hi, my name is Barry Kramer. I'm a 20-year resident of the city of Los Angeles. I'm a medical cannabis patient, and I am the operator of one of the 187 still unregulated cannabis dispensaries here in Los Angeles. I just want to remind the committee and the city council and whole that you have advocates here that have been with you for years and years on this issue. We've really tried to, we were there before the moratorium was put in place, urging you to pass the moratorium. We were there before neighborhood councils were aware or upset about the situation in their neighborhoods, my neighborhood as well. I'm upset about it. We were there the day you passed the moratorium and begged you to please move swiftly to pass regulations to avoid the situation that we knew we would be in, and here we are 2 years later. Now we have Carmen Trutanich coming in with his third recommendation for a draft ordinance, and I'm just going to read this. California Narcotics Officers Association training luncheon. The topic is the eradication of medical marijuana dispensaries in the city of Los Angeles and Los Angeles County. Please join Carmen Trutanich as he talks an in-depth presentation on future strategies concerning the eradication of medical marijuana. This is not in favor of patients that are here in Los Angeles. This is a city attorney who's out to get the patients of Los Angeles. Thank you.
Sarah Armstrong, Robert Kahn.
Good afternoon, everyone. My name is Sarah Armstrong. I'm one of the founding members of the Working Group for Medical Marijuana Ordinance. I come before you today to urge you in the strongest possible terms to reject the city attorney's draft and to accept Mr. Reyes' draft instead. I think it is a much more fair and balanced document, and I'm very, very hopeful that within that draft you will make the decision not to waive the warrant requirement when you want information about medical marijuana patients. I prepared a letter about this subject for you. I hope you'll read it. I am very concerned because you have 14 cross-sworn officers on the police department, and if these people are allowed to just walk into dispensaries and grab any information they'd like, they can then take that down the street and prosecute federally. And it happened in San Francisco. It's not out of the realm of the possible that it could happen here. So if you would read my letter and take this into consideration, I would really appreciate it.
Thank you, Ms. Armstrong. Robert Kahn.
Hi, Robert Kahn. I'm an attorney for LACA, Los Angeles Collective Association. I'm the attorney that's prosecuting the civil lawsuit that I brought. I just had a couple of comments. One is, I don't want to cover what other people covered, that the ordinance should take into account the reality and the legality of the sales of marijuana. Two is to not try to distinguish between the pre-ICO and the post-ICO. That's the basis of our lawsuit. That's just going to create more muddy waters. And the third comment is, and I heard it said over and over again, that you're giving people fair hearings for the hardship. Councilman Zine, is that what you said? Correct. Do you think it's really a good idea to refer to the people that are applying here for hardship as greedy bastards in the radio? I think that was really bad. To refer to them as a bunch of greedy bastards. I don't think that
What I did refer to is those who were violating the law. I did use that comment on the radio. Those that are violating the law, that's what I stated, and I stick by that statement. Correct. I referred to them as greedy bastards on the radio during an interview.
Okay.
Those establishments that are running illegally in violation of the ordinance, in violation of the hardship.
Okay, well then I would just ask you, after it's been determined that the ICO has expired so that they're not violating the law, are you going to apologize to all these people that you
We'll
call
cross
greedy
that bridge when we
bastards?
come to it, sir.
Okay.
Thank you.
Let me, if I could add to that, I think I want to commend Mr. Zine for being one of the first to stand up in this city council to support the safe access to medical marijuana. But I think what he was referring to, which is something that I probably would have used the same description, is that there are people out there taking advantage of the city's grappling with a very difficult issue, where the federal government says something, the state government says another, and this is a very new issue for any municipality to be dealing with. And people are jumping in right now for the sake of profit and making a mess and putting even more in danger those people who need access to medical marijuana. I would say that these people who are jumping into this and making a profit of it are putting in jeopardy people's ability to have medical marijuana, and is frightening away those supporters that ordinarily would be there. And that is what I think Mr. Zine was referring to.
Let me clarify that. And Mr. Duncan can attest to the fact that we've worked with him and his organization from the get-go. We've been to 3 establishments and observed the activity, and we've been very supportive and worked with the working group. And it's the people who are going outside the law, the people who are simply trying to make a profit, are the ones who are messing it up for those people that need it, and those legitimate distributors that are trying to help people. And the people who are in there for the greed of it, I refer to them, and I'll continue to refer to them as greedy bastards.
Okay. Our next comment will be from DJ Cote.
Good afternoon, Committee. DJ Kuti, District 4. What I present to you today is the beginning of petitions from patients who want to save their medical cannabis dispensaries, who cannot and do not have the desire to grow their own medicine, who want reasonable hours, who want protection in their confidentiality, and who also want to remind this committee that the original motion on the floor is to regulate medical cannabis dispensaries, not to regulate cultivation. I won't read the entire outline here. You can read it for yourselves. It would take up the rest of my time. I also think it's very frightening, Councilmember Zine, to roll back and talk about inviting the DEA to raid when you specifically asked them to back off so the council could do it themselves.
And I also ask for cooperation when we make a decision for them to comply with the law. And those that don't wish to comply with the law, there'll be consequences for that. I'm only focused on those that are violating the law and are not cooperating with us. Those are the only ones.
I still think we should do it ourselves and not invite the feds.
Not the people who are working with the establishment, who are trying to legitimize this, those that are simply out there to make a buck and don't care what this committee does, or what the city council does, or what the people of Los Angeles. We're not against the medical use, we're not against the rules, but those that want to flaunt the law and want to disregard what we do, there will be consequences for them, plain and simple.
No, I agree there should be consequences. I just don't think it should be the feds. We should do it ourselves. Thank you.
Thank you very much. Patrick Duff, David Lozano, Yanavet Bolanos.
Greetings. I hate to say it like this, but I watched him on TV say if someone files a hardship application, they can open after the fact. He said it himself. Now you're saying they're going to send the feds in to shut these people down. There's a location at 2823 Hyperion that I was at for a year and a half. Okay, we were evicted from the location on 6/29/09. They had a grand opening there. It's called the House of Cush Incorporated. I came to you a couple weeks ago, or a month and a half ago. Since then, the location that we had to move to has been raided by the police, harassed by the police. 3 people were arrested, nobody charged. The evidence that was seized, there's no receipt for the evidence that was seized. And I've been operating in the city since November of 2005. So way before the ordinance. A lot of these people also way before the ordinance was ever even thought about. But the fact is, this place at 2823 Hyperion Ave was made compliant by Tom Willis, the building inspector, and you asked Frank Bush about it a couple weeks ago. Frank Bush said he knew nothing about it when he knew everything about it. I went to him and I asked him, said, "Here, sir, I have the evidence." He says, "I already know about it."
Thank you very much. David Lozano?
That's racketeering.
David Lozano, Yaneth Milanos, Michael Bax, and Jeff Jones.
Good afternoon, City Council. David Lozama, patient here in LA. Indeed, these are callous times in which we live in. When representatives from the city attorney and district attorney last week came here and represented themselves as being supportive of medical marijuana, and now we have these same elected officials going to a luncheon with the sole topic of eradicating medical marijuana. This is pure about two-faced hypocrisy, and that is far more egregious than any topic here, that the community who come here faithfully to a hall of democracy cannot trust its elected officials to speak to them with truth and honesty. That is far more dangerous than any topic being discussed here. And as far as the DA, sicken us to the DA, all these people, we don't need any more stinking Packards.
Council members, if I could clarify and just make sure that everyone understands that the City Attorney's Office has consistently stated that we believe that medical marijuana dispensaries, meaning storefront models, storefront dispensaries, are illegal. That has been our consistent position before this committee, before City Council, and this flyer that everyone's referring to is simply consistent with that long-standing interpretation by the City Attorney's Office.
Good afternoon, gentlemen. My name is Jamilet Bolaños. I'm from District 5. I'm patient operator at Pure Life Alternative Wellness Center, and I'm a proud member of the Greater Los Angeles Collectives Alliance. First, let me state that I feel that Carmen Trutanich has totally disrespected and disregarded all the medical marijuana patients of the city of Los Angeles by his actions of late and by essentially reintroducing the piece of crap that Rocky wrote earlier. Now, let me say, too, that I've read your ordinance, Mr. Reyes, and it's besides the fact, a couple of things. One being that you have to give up the name of your patient cultivator and their address, which is totally unacceptable. It's a real ordinance, and I believe that it's a real ordinance because although I have not had the pleasure of you, Mr. Huizar, visit my place, Mr. Zine and Mr. Reyes have both been to my place, and I believe that they understand the need of the medical marijuana patient in Los Angeles. I believe that they know how much we've struggled and how much we've sacrificed to bring it this far, and I'm here to ask you today, please, give us an ordinance that we can work with. Don't let the city attorney's office poison you guys against us. You know how hard it's been for us, and you know how hard we've worked to get this far. Thank you.
Okay.
I just want to acknowledge the fact that you have worked with us, you have worked with our legislative folks, you and Mr. Duncan have been pioneers in this field, and we are the policymakers. The City Council sets the policy. There's other aspects through the legal channels from the City Attorney, the District Attorney, the Los Angeles Police Department for Enforcement. We set the policy, and the policy that we wish to set will permit people who need medical marijuana the ability to obtain that. How they obtain that is the dispute that we have. I'm supporting Mr. Reyes in his revision as the chair of PLUM. There's obviously some things we need to work through, but we've never wavered. We've never backed down from the fact that we want to establish legitimacy, and you folks have worked with us, and I acknowledge and I thank you for that. The other folks that only want to make a buck, that don't care, those are the folks that are messing it up for everyone and causing the situations taking place in the city of Los Angeles. Those are the folks. Only takes a few, and those are the folks who are messing it up for those who have good intention to help those people in need that need it so they can live that productive life. So we're on the same page. some of the spins that we can take care of, we will. The city attorney, the district attorney, they do not set policy. We set the policy, and that's what we're going to accomplish. So thank you for sticking with us.
Okay, Michael Bax, Jeff Jones, Ali Ross, Bob Allen, Lana Welch, and we do have, here we go, we have Jennifer Rivera from Councilman Hahn, and Emily King from Councilman Coretz. Sir.
Good afternoon, Council Chairman. Good afternoon. My name is Michael Backus. I live in Los Angeles. I operate Cornerstone Research. Frankly, I am shocked at the quality of legal advice that this committee is getting from the city attorney's office. What shocks me is the concept of reimbursement for cultivation of marijuana, which most patients who work with me simply cannot do, is not anathema to anything in California state law. And I am shocked that the city attorney cannot muster the perspicacity to get through what is a very, very simple concept. The idea is this, is that you collectively come together, you cultivate the marijuana, it costs X amount to cultivate it, that is reimbursed by the collective members to the dispensing organization. It's not hard, gentlemen. I provided information to council members Weezar's office today that will allow him to walk right through this and get the understanding that I know you've been seeking for quite some time.
Well, let me ask you this. What you just described, could it also be interpreted as being in a position to have over-the-counter sales?
Well, it's not over-the-counter sales because what we're doing is we have a closed loop. That what the Attorney General asked us to do was close the loop, okay, so that there would be no gray market in marijuana, that somebody wasn't going down to Tijuana and buying 10 pounds of weed and selling it in LA, okay? The idea is that members grow the meds. There are significant costs associated with that production. Okay, and I can provide those to the city. If the city wants to know exactly what it costs to do what.
But there is, in what you're describing, a moment in time where someone walks through a door and puts money down and receives marijuana.
Absolutely, without question. And,
okay,
it's legal because it's an incremental reimbursement for costs that collectively have been incurred.
See, and therein lies what we are trying to establish. Access.
Put it in writing for you. I put it
access to a person who is ill, who needs this medication.
I mean,
without creating the type of environments that this city currently is suffering through because of the greedy, you know what, that are out there, essentially disfiguring the city with the illegal activity. So that's the focal point of this third version, is we're trying to create an environment where people who are sick, who truly need this, have access and a way to receive the medicine without having to worry about the speculative nature of what has been occurring in the past. People are speculating on other person's illnesses, and that's wrong.
If I could just make one last point, which is that my feeling about the collective growing provisions that have been proposed by the city attorney. Number one, the plant limit counts are absurdly low, and their only reason for existing is to try not to trigger federal mandatory.
I'll ask for a copy of what Councilman Lasar has, but I'd like to review that. Councilman Lasar?
Circulate. Thank you. Thank you, Michael. And this is, you're asking a question, the crux of what is at issue for me with the new city attorneys, with the new city ordinance from the city attorney's office, which at last week's plum meeting, it was a discussion I missed because I had just seen that ordinance for the first time at this meeting and didn't have a time to digest it. And this over-the-counter no sales of medical cannabis discussion, as you see it, what do you think the city attorney is proposing in terms of if we cannot have over-the-counter sale of cannabis, as the ordinance is currently written, what do you think the city attorney is proposing?
I'd buy stock in the Avenues gang.
Okay, so they're not
Okay,
proposing...
because I think that'll be the biggest growing concern in this city, because that's where you're going to be sending patients to get their medicine.
Well, okay, they're saying that you cannot sell it over the counter, so there must be some other model, some other regime that they're describing.
The model of incremental reimbursement for costs is how our country works, okay? You can say that you can't make a profit. You can say that you can't make a profit. You can say that you have transparent books, okay? Intuit makes excellent software. We can track every single penny that goes in and out of our collective, all right? We organized as a nonprofit, all right, not to subvert the system, but to support it.
So what you're saying is to continue over-the-counter sales.
Absolutely, without question, because you can't ask a cancer patient to grow their own yew trees to make their Taxol. They need the medicine when they need it.
Okay. At some point, we need a description of what is the transaction that will take place if, in fact, we're not going to have over-the-counter sales. I'm still trying to grasp exactly what that means and what's being proposed in the ordinance.
Well, that takes us to a place where, quite frankly, I see a collision course between what the city attorney's been advising, saying absolutely no over-the-counter sale, versus trying to create an environment where we create access for those who need it for medical reasons, and that transaction needs to occur under some type of model, a model that has yet to be defined.
Yeah, because something is being prohibited, but then I ask myself, okay, so if we can't do that, what can be done? And I don't think we have sufficient information or description in the ordinance as to what will or will not be allowed, other than us prohibiting that from happening. And I'm not saying, I'm still trying to grasp this one issue here. If we can't do that, what then can we do?
I mean, you can go to a safe dispensary in Oakland, California, Harborside. There's several in Oakland. They're safe. Okay. They're in brightly lit neighborhoods. They're beautiful, and there are transactions in a non-profit way.
Michael, I visited your facility along with Councilmember Huizar. You don't have big signs up in front. It blends into the neighborhood. You drive by, you don't even know it's there. Your operation seems to be successful. You're serving the community, and I appreciate you working with us. The obstacle we're seeing is that the interpretation of collective, the interpretation of patient caregiver is, I grew up in my backyard, I'm the caregiver, you're the patient, I'm going to grow it and give it to you. People live in apartments and condos, they don't have yards, they can't grow it. Some people just can't grow it. Then the issue of, it's $20. You've got your rent, you've got your overhead, you've got to pay for that. That needs to be a factor which I think you're explaining. We understand that. But if it's $20 and they're charging $80, and the difference between 20 and 80 is their profit, that's where we come into the spin, where we create a problem. Somehow it needs to be balanced, where you can pay your bills, you can pay your counter folks, you can pay the people who are there. At the same time, the people who need it can go down and get it. And they can't then go to the place down the street and get a couple more ounces and a couple more. The regulations all have to be a part of it. And what we're trying to do is come up with something that'll work. What we don't need is the city attorney to block what we're trying to do on the policy aspect, because they write the ordinance. And the ordinance they write is what the law is going to be. So we need to somehow smooth that through, and Mr. Reyes is attempting to do that. But in your particular facility, which I was very impressed with, the one on La Cienega I was very impressed with, the third facility I visited, the man got shot during a robbery on Ventura Boulevard. I visited that facility the morning or the afternoon of the shooting. So those are the three places I visited. But they're different. The one on La Cienega has a different environment than yours, but I believe you're in there for the legitimate purpose of helping people. And that's what we're trying to accomplish. So whatever the prosecution side wants to do, the civil side wants to do, our intention, and Mr. Reyes, the chair of this committee, is trying to get it done after the third revision so we can move forward with this operation and we can let legitimacy take hold, and those that don't want to participate in the legal process, the consequences are there with building safety and prosecution, whatever.
Hey,
That's our goal.
Look,
Okay,
I thank you for your efforts because you've worked very hard. What I see right now is constant roadblocks, and I think that we're closer to the finish line than we think, and I think we should move as quickly as possible to get there.
We're trying that.
Okay, let's move on.
Mr. Bush wanted to make comments from building safety.
Okay,
Mr.
you
Bush.
want to speak, Mr. Bush?
Frank Bush?
You don't have to, but if you want to, come on up. He has to, okay.
I just want to address one thing. I know Mr. Duff mentioned that Hyperion property again. It was mentioned about a month and a half ago here that I didn't know anything about. At the time that day, I didn't know anything about it, but I do know he was evicted out of there. The property owner allowed another one in there. There's a hardship exemption that's pending right now. So just to let you know that we are on top of it and everything's being handled. As soon as it comes to hardship, we'll move forward with enforcement on it.
Okay. Here we go. Jeff Jones, Arnold Vance, Bob Lane, Norman Welch, Jennifer Rivera, and Emily Kane. Good afternoon, sir.
Yeah, my name is Jeff Jones. I represent the Patient ID Center, 470 South San Vicente Boulevard in Los Angeles. I would urge this committee to actually take up Zine and Chairman Ray's version of this ordinance. I feel that it's going to encompass more of a move forward than the city attorney's version. I have yet to hear the West Hollywood city attorney being brought in and question as to why their current policy is working, why the city attorney in Oakland has been missed, the city attorney in San Francisco has been missed, and why they currently have programs that are working. They have zero problems with greedy people that are coming in post this issue. They're able to shut down the facilities that are not regulated. The city of West Hollywood has no more than 5 open facilities, and anybody else is operating without a legal way. I would ask those that are not operating legally to not be taken down criminally through the DEA, but using our own means, keeping inside of excess money that might be made, and fining them civilly. Those are moves that have been made in other cities so that you show up and they're still under investigation, they're still operating. Give them a ticket, $500 the first time.
Mr. Jones, just to understand, what is a patient ID center and how are you sponsored?
We operate at two locations in California, first in Oakland and the second here in Los Angeles. Our ID center has existed since the closure of our dispensary through our federal case in 1998, issuing ID cards that are recognized by municipalities including Oakland, Sebastopol, and others under ordinance, and some municipalities in a more
how does a person get an ID?
They have to provide our agency with a current recommendation that has been issued by a separate California physician. We do not employ doctors nor directly refer them to individual doctors, but to
So a doctor can fill out a slip and say this person qualifies for an ID to buy marijuana?
Our program actually mirrors the state identification card program. We existed prior to that. I actually advised on SB 420 when it was created, and we implemented the state ID card program in Alameda County under contract, currently still operating with the health department. So my agency is one of the only agencies that issues both a private ID and the state ID, but only for Alameda County residents do we issue the state ID. It's operated by each health department in each county, and Los Angeles chose to run their own health department program. So we refer clients that want the immunity card here in California, in Los Angeles, directly to the health department. Our card is more of a user card backing up the defense of Prop 215.
So the collective model or the...
We're incorporated as a cooperative actual corporation in California, so our members that are identified own our cooperative.
Okay.
So we're actually one of the first incorporated cooperatives in California. We incorporated in February of 1997, trying to move forward as a dispensary, but now are actively just an ID center. So our members own our identification center. And they're all qualified patients that have a current note on file. The card actually expires to the date of their note that's most recently on file with us, and the caregivers are tied to their membership file, so that unlike the state card that expires 1 year from the date that the health department issues it, our card expires the day of their recommendation.
But they kind of document those calls, so it could be manipulated and copied, etc.
Well, we have a verification system online and through a phone-based system 24 hours a day that validates a driver's license and their member number, so that we use a dual identification so that they can't render a fraud card from us without committing a separate crime, because they would need to commit identity crime under the DMV regulation. Okay. All of our members have to be checked in with the Department of Motor Vehicles either through an ID or a driver's license. So even some of our disabled members that are bedbound still have a current ID from the DMV. And we demand that because we want people to be recognized by police, easily identified, and we want it not to be a question of who they are, but whether or not they can qualify to possess.
Committee doesn't allow me to do that. I think we need to have another conversation after this.
Can I ask a quick question? State law provides that a doctor can make a recommendation to a patient that they use cannabis. That doesn't have to be in writing, does it? Or does it have to be in writing?
We don't issue ID cards that aren't based on with an in-writing form. We actually deem appropriate, because we're custodians of their medical record, that we want their medical record on file, a diagnosis and their statement of recommendation from a doctor.
You actually ask for records, not just
We
the
actually
recommendation.
keep on file in our agency in an encrypted form digitally a record of their file, so that if they lose it, they can come back and get it from us. We issue an ID card replacement for $15. Our normal first-time visit card is $40. A renewal is $30 unless it's by mail, and that's $35. The fee is quite reduced compared to what the state card is. In our Alameda County office, we charge $103 unless they're on Medi-Cal, and that's $51.50. Here in LA, it's $153, and some folks just don't trust the state to get an ID card from. It wasn't but just 13, 14 years ago, our current Attorney General was after us, viewing all of us as criminals.
Don't take offense to this question, but does your existence determine on the number of ID cards you have, or are you funded through the state funds, knowing the condition it's in, but who pays you?
We're funded by our members, so our members are funding us by renewal fees. We also operate a small retail store that sells items related to T-shirts, books. We teach members how to grow, so we do something that doctors can't do by actually helping them find places to go.
So are you a state entity?
No, we're a private cooperative corporation that's incorporated here in California.
Recognized by the state?
Correct, in contract with the health department locally in Alameda County through the state card program.
Oh, okay.
For Alameda County only. We don't issue state cards except for in Alameda County under state contract. In LA and in Oakland, we issue a private ID card that's separate and different, but it recognizes the Prop 215 defenses that exist under the California law that was passed by the voters.
Having worked with several jurisdictions, and the current structure we have is that local governments are setting up their own regulations, et cetera. Would you agree or disagree that it should be the state that should license the dispensaries and issue standards for operation, et cetera, or to be
Well, long
consistent?
term, I would agree with that, but-
consistent, or do you think it should be as it is now, having local jurisdictions make up their own?
That's a two-phase question, long-term and short-term. Short-term, for your immediate control and for not having problems related to unlicensed dispensaries, you need to regulate them right now, and the state is not offering you that guidance nor that law to cite. Long-term, I would welcome the state to provide further clearance and, as you would say, enabling language. The last enabling language for SB 420, which was a cleanup bill, was vetoed by Governor Schwarzenegger along with 2 hemp bills. His current stance on our issue is not favorable to helping to sort out the mess. So I would want you to act expeditiously, following up with the current 1C version of an ordinance, adding in at least lessening some restrictions about verification, making sure that you're making it easy for patients to get in and out of facilities with some thought about making sure that they're not abusing the system. I think that if you set up something transparent and easy, like the city of West Hollywood, Oakland, San Francisco, and many other municipalities that have chose to regulate, you're going to see an end to the problems that are existing. In Oakland, the last 3 staff reports that have been issued have all been favorable. The police have come forward saying that this has helped to sort out the mess. They knew who's operating right, and they knew who's operating wrongly, and they can fine or otherwise stop those people directly.
Okay, thank you.
What have these other jurisdictions done to close those that are running illegal? The ones that aren't compliant, how do they close them down?
One instance in Oakland, they did use an assisted DEA raid because the person just didn't respond to any citations. In Oakland, most of them have been voluntarily. In San Francisco, because they get cited with either a denial notice or not having an approved permit, and they close down because of having a cease and desist order sent to them. Because you don't have an operating law, the follow-through, as was mentioned many times by the committee, is that there isn't seemingly an enforcement mechanism that's there for them. Once that's clearly identified, many groups will stop operating when they know that the folks are going to come and shut them down. Right now, it seems like the mechanism is a little bit disjointed because it's new, and this is a new policy, and we're here to welcome this and to hopefully allow regulation here that's going to allow this issue to prosper through controls and through neighborhood support. We don't want to be in an area in the community that's not supporting us.
Okay.
Final question. The other jurisdictions provide over-the-counter sales, correct?
Correct. And some provisions allow for inspections of books like in Oakland, so no excessive profit is made, where the city can come in and check their differences of their figures, both their prices to pay for the medicine and also the incomes that they show in expenses.
Now, last week we had a number of law enforcement officials come from Long Beach and other places telling us that that's illegal under state law. I mean, so we were left with a question that those who are operating today and have kind of come up with some set of regulations, they're all doing over-the-counter sales, and we were told they're all doing
I would just, again, revisit the idea that many cities that have grappled with this and acted quickly, like in Oakland, did so with quick execution and very little side effects and have not been stopped by the current state. Who right now would be the arbitrator of that? Attorney General Brown, who was the mayor of Oakland when they authorized over-the-counter sales. Not only does the city benefit from it, but 80% of the voters almost passed an additional tax that you know about that's going to raise the city upwards of $400,000 to $1 million, in addition to the permit fees that roughly figure $120,000. If you were to similarly set up a program, not only would you be able to regulate this industry, but you would probably have a surplus to hopefully pay other debts down that the city of LA has in its general fund.
Okay. Okay, all of us, Bob Ryan, Robert Welch. Good afternoon, sir.
Greetings in the name of the Most High, Jah Rastafari, Jehovah Sela, Rabboni, Almighty Yahweh, Jah. Brothers and sisters, city hall members, people work, I'm glad to see that, like, ears are listening right here. Today is the first time I really feel that. I want to say that Detective Pam Pitcher, 4 armed robbers, because of Reverend Patrick Duff, today is serving over 20 years, who came to dispensaries with arms, with guns. Patrick Duff needs the respect of the city. I'm not a resident of this city, and I'm proud to be. And I will always be here. My family too, like Ziggy Marley, Rowan Marley. Tonight, Julian Marley will perform here in LA. We're Rasta, not because we're Rasta and the sacrament is marijuana, but I'm also a sick person. I was beat up by over 22 Philadelphia finest police. I'm still sick. And marijuana is what really makes me calm and make me feel better.
Thank you, sir.
I want to thank all of you for listening, please. Because I see that.
Thank you very much. Bob Ryan, Robert Welch, John Rivera, and Emily Kane. Good afternoon, sir.
Good afternoon. My name is Bob Lang. I'm a cancer survivor, cannabis activist, and an educator. I want you to work really hard on these regs and remember that the law enforcement community is aligned against you in many ways. Groups like the California Narcotics Officers Association find huge financial gain leaving the system as it is. Most of their money comes through forfeitures, through their training and stuff. And I find it reprehensible that these groups align against sick people. This issue's been facing you for years now, obviously, and these same forces have been in place against you this whole time. I think it's clear that there are ways to do over-the-counter sales legally. The Attorney General has spelled out guidelines that involve sales of sorts, and I think it behooves you to find that common ground and remember that there's interests here that don't want cannabis in this community, obviously, through the luncheon that you see is coming up, and I wish you'd find that common ground for the safety of these patients here.
Thank you very much. Okay, Robert Welch, Jennifer Vaughn, and Emily Kane. They'll conclude the speakers. Good afternoon, sir.
My name is Norman Welch. I'm a medical marijuana patient. I have severe back pain. It gets me through between my nerve blocks, which are every several months. I acquire my medicine from members of GLACA, which you all know about from the working group. They were able to self-regulate during all this period when regulation's up in the air. So my hat's off to my friends at GLACA. All I can say is to the people who would look toward the city attorney's ideas of stopping the storefront sales, I can't grow it. It's the only way we can do it. Cash has to exchange hands. So please, I ask you, do not turn law-abiding citizens into an underground economy where we pay our taxes. Let us pay our taxes. Let us have our medicine. Don't push us underground. We're respectable people. We respect the law. But you see that we're not going to go away. We're just not going to go away.
Jennifer Rivera and Emily Kane.
Jennifer Rivera with Councilmember Hahn's office.
Good afternoon.
She just wanted to go ahead and said thank you to all of you. I know that you've
We
been
didn't
working-
hear that first. Can you start all over? The microphone didn't
Start
catch
all
that.
over again. Okay. Can you hear me now?
Yes.
Better? Okay. Jennifer Rivera with Councilmember Hahn's office. So I'm here today to say thank you to all of you for taking the time. I know it's been a long process. We've been working closely with Councilmember Reyes' office, and we do support this ordinance. We do have a few concerns that I'll list, and I hope that we can move this forward as soon as possible, send it to full council for full discussion so that we can kind of move the process along. Number one, I know I've been here before, and she still feels strongly that 1,000 feet may be too restrictive for some of these collectives, and, we urge this committee to reevaluate that. Maybe make it 500 feet between sensitive uses. Secondly, she feels that the ordinance calls for memberships to be updated every 2 months. I think she believes this is a little too inappropriate. Maybe a quarterly basis reporting would be more appropriate to space it out a bit more. Along the same lines, the ordinance calls for full disclosure of members' name and addresses. She feels that this violates their confidentiality and that may be too intrusive, so urges this committee to reevaluate the disclosure. And in reference to the 186 registered collectives, the ordinance calls for 3 months for them to comply. This may be too stringent and urges this committee to reevaluate the allowed time for these collectives to comply and perhaps also give them some type of location priority. So, thank you very much.
Okay. Thank you, ma'am. Thank you very much. Yes, go ahead.
Hi, Emily Kane from Councilmember Paul Koretz's office. He apologizes that he was unable to be here, but wanted to make sure that his concerns were voiced regarding this ordinance, specifically regarding the privacy rights of patients with regard to the maintenance of records and the inspection authority in the current ordinance that specifically requires patients and individuals to give their names, phone numbers, and addresses, and then resulting in opportunities for law enforcement to go and collect those records directly without any other warrants, searches, or police requirements. He's very concerned that this will inhibit people's ability to maintain privacy rights and that it will be dangerous for individuals. As we know, the realities in this country regarding this issue may not be safe for patients to disclose these records as such. And he looks forward to working with everyone and is generally supportive of making sure that this ordinance goes forward. Thank you.
Thank you very much. That concludes the public hearing. We've been having discussions throughout the public hearing, and just to be brutally blunt, we've been doing this for 2 years. We've had, I think, extraordinary effort in trying to reach a balancing point for those people who are ill versus creating the safeguards where people will not be speculating and increasing the drug trade in the form that's unhealthy for this city. And that's been the real challenge, I think, for this committee. After 2 years, we spent sessions with the advocates. We had various discussions with various departments. Quite frankly, the city family was trying to figure out, okay, how does this happen? No one's ever done this before. Which departments actually handle this? And we saw different reactions. The city attorney's office, I want to thank the staff that's here today and the staff that's been sticking it out. I know we've been caught through 2 different administrations, which doesn't make it any easier. But there's been a fundamental area of concern as to how this ordinance will actually be implemented. I think what you see here today, there's enough, I think, give and take. I know there's concern about the over-the-counter sales. I know that's a fundamental issue and a fundamental step. And I've been hearing you loud and clear. Other cities have done it. Why can't we? And so therein lies, I think, the question that has to occur with the city council. What I'm going to try to do today, colleagues, is put forth the ordinance with instructions so that we can move it to the full council, and the city attorney can advise us. Do we have this discussion? We need to have this discussion in the most transparent way possible. It needs to get to 8 votes, maybe 10 votes, which means there's going to be more opinions and more feedback give and take from the rest of the council members. So this is going to be, I think, the beginning of the second stage. Quite frankly, for me, the sooner we get an ordinance in place, the stronger the regulatory parameters will be set, and the quicker we'll get rid of the bad guys who are truly just here to make money off of sick people and using those who are sick as a reason for making money off of others. And that's who I really need to eliminate, and those are the greedy you-know-whats that I think Councilman Zahn is referring to. So I do have some instructions here, but colleagues, you have any questions or other? Do you want to go through the instructions? How do you want to have comments? Do you have comments to make?
I have one that I think the city attorney needs to do some research on the requirements regarding identification and having a register. HIPAA, which is the federal regulation on medication and privacy. Can we check and see if there's a conflict with that when it comes to maintaining the record, which is accessible to authorities? Because I know in the medical field there's all kinds of HIPAA restrictions. I would ask that be researched. One question that I didn't see, the facilities during business hours open for inspection by building and safety, fire department, police department, only during business hours. Is that in there? That was one of the requirements we wanted to have, that they'd be open for inspection.
And this is, you're requesting that they have inspections, please? It's in here.
That they'd be permitted, in other words.
Yes. Jerry Burge, City Attorney's Office. Yes, that is in the proposed ordinance. We think it's between 10 a.m. and 8 p.m., but we can check that.
I think what we should do is just have it during business hours instead of putting restricted hours during business hours. And obviously, we don't expect a parade of law enforcement to go through, but to show that it's done in a legal fashion, as there would be a bar or any other establishment open to the public, it would have the same condition that because the facilities, the places I visited, they're always secure with security officers and gates, etc. And we don't want to have the police impeded when they're doing a legitimate inspection at a site, but that there would be a condition, just to make sure it's all done legal, that they would be open during business hours, permit law enforcement, building safety, and inspection. Okay, thank you.
Okay, questions, Councilman?
Thank you. Well, let me first state that this has been a long process, and as a member of this committee that was first presented with the original ordinance, I got the sense that the committee at the time wasn't excited about what it saw as an over-heavily law enforcement approach to the paradigm that we were creating with respect to safe access to medical marijuana. But as I've listened and gone through this, at our disposal, we're in a planning committee. It took a very heavy planning approach in coming up with an ordinance. On top of that, we asked our city attorney to look at it, which the criminal division was dealing with it, which we got back a very heavy law enforcement approach to it as well. What has been critically missing from this whole debate was the health perspective, which is what this issue is really all about. And I think therein lies the struggles that we have had in coming up with something that makes sense. Because I've gotten the sense that the advocates who come up and speak at every meeting are much more informed than we, the decision makers, because it wasn't at our disposal to be informed and know where to go to get the type of information that would help us create these regulations. And I think that has been a big misstep for all of us. I'm not putting blame on anybody. That's just what we were given in this new territory that we're all undertaking. And although I'm at in 100% agreement with the proposed ordinance as is, and I'm certainly going to propose some amendments when it comes to full council. I do believe, and I agree with our chair, that we should move this forward to full council so we continue to, or we come up with some regulations. I think we will be in further danger if we take no action. We need to come up with something so that we all know what are the rules and regulations. Everything is pretty murky right now. It is a mess. But if we move forward and let the 15 council members hatch it out, that's me.
Work it out.
No.
Sort it out. Work it out.
Two things. No pun intended to the topic. And secondly, that's my bilingualism coming out too, so that's the other reason. But I do think we should give it to the full council and have us all discuss it and debate. I think it'll be a bigger disservice to all of us if we continue to have it in council. So I support that. I do have some questions, Mr. Chair. I don't know if I should wait till after you give your direction. Maybe I might get some things clarified. If not, I'll follow up with some questions that I have.
That's fair, Councilman. Let me go through the instructions. I'll just paraphrase them. There's a lot of technical language in here, but let me try to keep it concise. And again, this is with the intention of putting it in front of the full council, with the intention of creating an ordinance that actually puts regulations in place, and we're going to leave it up to the 8 to 10 votes that can be determining where this will ultimately end. So, that being said, I would move that we adopt 1A and forward that to council. But I want to make sure that 1A is agendized at the same time as the ordinance that we're going to speak to, which is 1B. And 1B has a set of instructions that essentially amends the third revised draft city attorney ordinance. So these instructions amend the third revised draft city ordinance. Okay? So the ordinance we received last week, these instructions amend that version. So I'm very clear what this committee is doing.
I'm not clear what version is 1A, Mr. Chair.
Okay.
Which one is 1A?
1B is what I'm focused on. 1A is the design motion. It's a motion he put forth. 1B is what I'm speaking to right now.
Okay, so 1A is the original motion as proposed by Mr. Zine and yourself, and then 1B is the city attorney version?
No, can you clarify, please?
1A, Councilman, is a recent motion by Councilman Zine asking for a legal interpretation of various law cases, and I believe there's a city attorney report that was submitted today. Right.
So it's a clarification. It's a motion that Councilman Zine put forth that instructed the city attorney to review 4 cases. And those 4 cases is what we're going to be hearing as a result of our action with 1A. And that's it. That's all that does. 1B is the actual ordinance that came forth last week, and the instructions I'll be referring to is attached to that version. So I'll try to be as concise as possible. So for 1B, instructions of city attorney, in amending the third revised draft city ordinance, 1A instructs staff to explore alternative registration procedures within the city other than the city clerk office. So it allows us alternatives in how to do the registration procedures. The second one is we want to remove an impractical sentence, which is the failure or refusal of any member of the collective to sign, initial, or only amend the registration for shall result in the city clerk refusing to accept the registration form. So that's what we are omitting. Number 3, we're allowing updated information on a quarterly basis. Number 4, We're adding as a requirement to registration the pass of a background investigation. Number 5, we're amending to allow the Department of Building and Safety fee to include the cost for required research and an inspection. Number 6, we are instructing to amend to identify for each operating standard the appropriate city department responsible for verifying, enforcing, and confirm with building and safety, if any should be verified prior to the opening of a collective. Number 7, it pertains to definition. That's adding to collective definition that the trigger is 3 or more persons with ID cards, designated primary caregivers who associate. So that's the change that occurs there. In terms of regulations, conditions of operation, and planned quantity, we will aim to replace the planned quantity cap and pounds of dry marijuana allowed on property. So that's, we need to leave that rather open at this time, since we need to get more information and hopefully more insight from those who are more familiar with this. So that's something we're going to focus on. So at least for that flexibility. In terms of existing medical marijuana dispensaries and failure to comply, on number 9, increasing the 90-day grace period to 6 months for the 186 registered with the ICO to comply with city ordinance, and also giving the 186 priority regarding location restrictions. So the 186 that are in place will be given that position. In terms of regulations, development standards, we're going to add standards on where the collectives can locate, separate from the 1,000 distant requirement. And we're going to be attaching more instructions. Did you guys want me to go through the actual specific detail, or you can make that on your own when you review this? Well, let me just go through it real quick. The development standards, 1 is the property shall comply with the provisions of Chapter 9 of the Code. 2, no collector shall abut or be located across the street or alley from or have a common corner with a property improved and exclusively residential building. 3, no collector shall be located within a 1,000-foot radius of a school, public park, and playground, public library, religious institution, licensed shower care facility, use in hospital or substance abuse, rehab center, or another collective. So those are the specifics on those standards. Let's see. Then we have 12, our last, is we will be modifying the method to measure distance, which is easier to administer.
The next 2 are separate from the 400.
Do you want me to read this now? Okay, and in terms of other amending language that we'd like to introduce, will be instructions to other city departments. Planning and zoning component, addition of discretionary review and city process, on-site consumption and deviation from distance requirement. So this will be carrying the general instructions, recommendation to have planning work in consultation with the city attorney and the CIO on land use zoning ordinance. The companion piece to the city attorney ordinance considered to include on-site consumption and deviation from distance requirement as factors for public hearing discretionary review process. So that will trigger a whole other process of those features and types of activities are included. In terms of fees, we'll be instructing the CIO in consultation with the CRA and relevant city departments to develop a fee study for the city ordinance and to investigate a taxing scheme for it as well. So we'll see if there are any taxing models that could be reviewed and or suggested along with developing the fee for the study. So this is a thumbnail sketch of 4 pages of technical language, but it gets to the gist of what we're trying to do. On 1C, we can receive and file, since most of what I brought up in my motion on 1C is being addressed on 1B. So I can receive and file that motion. And 1D, we'll be instructing the planning department, working with the CLA and the city attorney to prepare and process expeditiously the land use planning ordinance for city planning commission and city council consideration. The goal to adopt before or by mid-December of 2009. So I believe that covers everything. I thank Guadalupe and my staff, Susan and Rebecca, for their unwavering focus along with the city attorney's office. But they will take a large portion of the enabling language for us to move forward, and we can get into a full-blown discussion in front of full council, knowing that we spent 2 years trying to put forth the best language possible, understanding the tensions we have between federal and state, and quite frankly, the legal opinion that we can't have over-the-counter sales versus trying to define a model that addresses the needs of those who are medically in need of this medical cannabis. Any other instructions or input, comment? Councilor Zahn?
Thank you.
No?
I still, like I said, I'm not in full agreement with the ordinance as it is moving forward, but I do think it should move forward. However, I'm still trying to understand, if we are not asking or we're prohibiting over-the-counter sales, what is the paradigm, what is the structure that we're creating for these transactions to take place? I'm trying to really understand that and how that works.
Heather Aubrey, City Attorney's Office. With respect to the issue of over-the-counter sales, just to reiterate, state law does not provide authorization for sales. So the mechanism envisioned by state law is clearly cultivation by the qualified patient, him or herself, when able to do so. And when not able to do so, the primary caregiver for the qualified patient is envisioned as the person who would do that. Clearly, the law recognizes that if someone is too sick or ill to actually cultivate for him or herself, then a primary caregiver should be the appropriate person to do that. And of course, there's abundant case law that discusses who qualifies as a primary caregiver. Certainly also the mechanism of collectively coming together and cultivating. And within that framework, both qualified patients, those with ID cards, and primary caregivers can come together and cultivate. And if within that framework, a qualified patient is unable to physically perform the labor, then certainly within that collective group, it is determined the appropriate level of physical participation in that endeavor. But by no means does our ordinance require that every qualified patient cultivate for him or herself. And I think the record should be set straight on that.
Okay, so let's say there's a collective and there's a patient, has a card, is a member. They would pay some fee or they would pay something associated with the cost to operate that collective, correct?
Our ordinance does not envision a business model, because actually a business model is not what is required under state law. In fact, we think that would be too restrictive. Mm-hmm. In other words, certainly a collective can organize itself however it may see fit, but it's the activity which is specifically authorized or an affirmative defense is created for certain individuals, which is critical. And it's the activity of sales, which is not, there is no affirmative defense for that activity.
I see. So the collectives would it would be up to them to decide how they operate within themselves to pay for the costs associated with growing the marijuana.
Certainly, within the
they can't do a cash transaction.
Exactly.
So you owe us this much money because it cost us $100. We have 50 members, so every person is going to give $2. They can't do that.
That's correct. And just to be clear, what is envisioned is that when the members come together to cultivate among themselves, any costs associated with that collective cultivation project can be spread among the membership. And that is very different, however, from an over-the-counter sale transaction. when you have individuals who are simply purchasing after the fact and were not directly involved in the collective cultivation project.
Okay, thank you very much for that clear explanation. Can I ask, is it Don, what's your last name? Don? Duncan. I've seen you come testify several times, and can you state your title again, please?
Don Duncan, California Director of Americans for Safe Access.
Thank you. And you've spoken to this issue before, and I'm still trying to understand this. So you heard my question, you heard the answer. I, as a decision maker, having to vote on this, I'm trying to figure out what is the best structure we can create to get to the issues of safety, of getting access, of neighborhood respect, etc. All that stuff, legal versus illegal under state law. What is your perspective? Given, not if you agree or disagree, but let's say, if true, that you cannot have over-the-counter transactions, what do you think this ordinance is envisioning, or how will these collectives operate?
Well, this ordinance seems to be based on a sort of fictionalized account of medical cannabis. The state law does, in fact, explicitly authorize the sale of cannabis inside the context of a legally organized or operated collective. This ordinance pretends that medical marijuana facilities are some sort of idyllic Maoist commune, and everyone simply shares in the labor of producing medicine, and that's not a interpretation that's consistent with the statutes, with the interpretation of the courts, or with the Attorney General's interpretation. In fact, it was the intent of the legislature to create these sorts of facilities, and that's reflected in the Urzucano decision. There seems to be a lot of preoccupation with the phrase "over the counter," and that phrase, from the talking points of our opponents, is not a phrase you find in the law. The Health and Safety Code, 11367.775, specifically exempts collectives and cooperatives from penalties for possession or possession for sale, with the express intention that the collectives and cooperatives would be exchanging money within their membership. There's no practical or real way for that incremental reimbursement to occur inside the context, except for the individual member who is acquiring medicine to pay for it. Now, obviously, there's a concern about profiteering, and I certainly have suggested in the past ways that we can deal with that by requiring certain corporate structures or reporting. But the fact that money changes hands over the counter doesn't make it a for-profit transaction. The fact that money changes hands is just a very practical and normal way that the cost of cultivating medicine is allocated amongst the membership. There's really no other way to do it. And so we need not be hung up on this phrase, over the counter. Whether the sales happen over the counter, under a basket, or standing on your head, they're legal. They're legal in California, and that's why other cities and counties have moved forward. And if you're if it's a concern of this committee that the city attorney's office consistently opposes this sort of transaction using the phrase over the counter, I would respectfully submit, and I don't mean to offend or accuse anyone, but I think if you look at the sort of document that was circulated today regarding this event coming up about eradicating medical marijuana, I think that speaks to a mindset that may be reflected in the opinion you're seeing about over-the-counter sales. Other city attorneys, other city councils haven't found it necessary to eliminate cash transactions or to prohibit that sort of normal functioning of the collectives. These sorts of facilities are working, they're licensed, and they're operating just fine in cities all over the state. And so we don't have to jump through so many hoops. We don't have to start from scratch. I think, by the way, this committee makes a terrible error in sending this version of the ordinance to the full council before these crucial issues are solved. I know you're tired of talking about this, but we really need to address this issue before it goes to council. Otherwise, we're going to be having this debate, but 5 times larger. So let's please don't do that.
Yeah, and I think we are faced with a situation where we're getting some advice from our city attorney, and generally the three of us up here have been very supportive of the model you're describing. So it is a real issue. If we send it to full council, I believe we're going to be able to get more minds involved, and perhaps, and not stall with time. And I'm very concerned about all these hardship exemptions we have out there that people continue to operate when they shouldn't be operating. And they're some of the ones that are not being as concerned with local neighborhoods as they should be, and they're the ones that should be targeted and taken out of business, and we have to do something. So in my view, I want to do this as quickly as possible, but let me ask you this. Is it reasonable to conclude that if we take the ordinance as is, that we're going to see very limited or very few collectives actually exist in the city of Los Angeles?
I don't know of a single collective in Los Angeles, whether it be pre-ICO or post-ICO, that operates in a manner that's envisioned by this ordinance.
It's impossible to
Not a single one.
exist. So by prohibiting one model or prohibiting what's existed, there is no other way to function.
In my opinion, no, there's not. And if we can't come to a common ground on the issue of sales of cannabis, at very least, please don't prohibit them, and then the state courts can do what they may. But let's don't put a restriction on the patients about sales of cannabis.
I got it. And let's follow this argument. So if you cannot operate, given the ordinance that's being proposed today, certainly we wouldn't have the voters approve Proposition 215 to envision something to exist, correct? So there's got to be something there that the voters envisioned.
And that the legislature envisioned with SB 420. In fact, that's what the court said in Condo, was that the legislature must have envisioned these sorts of organizations because they specifically enumerated the health and safety codes for possession and possession for sale as codes from which collective and cooperative associations are exempted. And so if we can't agree that that can be enshrined in the code, let's at least don't forbid it. Let's leave out any language that prohibit a cash transaction for a patient participating in their collective.
Mm-hmm. Another perspective, this is the possible slippery slope that exists with cash transactions. I think that, I could see some thinking that if we allow that, then you allow other types of people to get involved who are interested in the profit and not necessarily providing the cannabis to those people who need it. So that although our attorney is advising it's outright illegal to do that, and some may say, well, illegal, it's probably could lead to those who want to, make a profit out of this. So thank you for that input. I appreciate it.
And there are ways to deal with that, and I know this committee is finishing up, but if you want to discuss that more, I'd be glad to entertain it.
Okay, thank you. And do you have a question?
Don, I have a concern if we don't move it forward and have further debate with the full council. Well, we all agree with you, with the collectives that are following the rules, as loose as they may be, it'll linger for another year. We've got to move it on, and I think between now and then, there can be some more modification to it. But it really frustrates me from when we first met, we did the interim control ordinance, and we had to get an extension, and now we're here 2 years later. I visited establishments, I saw the man get shot. We need to come to a conclusion. We need to put something on the books where you folks can operate without feeling the fear, the intimidation, and unless we move it forward and we continue to debate it here, there's 3 out of 14, because we've got 14 council members now. If we don't do it, believe me, it'll be another year. And then by the time we finish it, it'll be 4 years, and you'll throw your hands up and say, is anything going to be done? Then we'll have 2,000 operating in Los Angeles.
I know, and many times I've said, please hurry, and I don't want to retreat from that. All I want to tell you is that if you cannot agree right now on what is legal regarding sales, just leave out the language that makes it illegal.
We don't agree with what's in front of us, is that as the stewards of this municipality, our legal advisors are saying to allow for over-the-counter transactions illegal. And so we're trying to find a middle ground that allows us to create an environment where we do not neglect those who are medically in need. And so therein lies, I think, the core of the discussion that's going to be in front of the 15 council members, or 14 at the moment, is what are we going to do as a city? How are we going to listen to the Los Angeles Police Department, who came last week with other police departments, other cities saying, you shouldn't, you better not, it's not wise to do this. And you have that environment from the legal point of view, from the law enforcement point of view. Now you have the health side point of view, which is something we're learning, as Councilman Rosales is saying, if we do that, you're going to push us towards the gangs and on the underworld that's going to hurt us even more. So therein lies, I think, the core of where we're at after 2 years of trying to get to some practical approach that deals with security in the city while being compassionate to those who truly need it. And that's the balancing act, and we need to push this forward.
I 100% respect your goodwill in this regard, but if we go to full council with an ordinance that does not allow for the sales of cannabis in the legal context of the collective, this community cannot stand
No,
for it.
what I'm saying is that in that discussion, it might come in or might not. It depends on the 8 votes.
So, again, we are the policymakers. Our policy is to move forward where we can come up with a plan where you folks can distribute to those in need, the caregivers, etc. Another item, the robberies. There's a lot of cash that takes place. What would be the opposition if there was a restriction? You'd have to have a credit card or a check or a cashier's check. If we could eliminate the cash, we could eliminate the potential for robberies. What about that component?
Well, you could eliminate the cash by requiring daily bank drops and restricting the storage of cash overnight, as in West Hollywood.
That's part of the restriction there? The
In
ordinance?
West Hollywood, yes, they can't store cash overnight, and they have to do daily bank drops. Some people are always going to use cash, and the problem isn't that they're using cash. The 7-Eleven next door to my house takes cash transactions all day. I'll bet those guys are taking a lot more than the average medical marijuana
What if
facility,
they
but
put
they
an
have
ATM?
cash handling processes in place to deal with it.
What if they did an ATM machine there, and they had the cash in the ATM? What I'm trying to do is
They could,
eliminate the robbery potential. So if you had an ATM machine, and they don't want to use a credit card or a cashier's check or a check, an ATM machine, as you go to a wonderful place, Tito's Tacos, cash only, ATM machine there. What about that? I'm just trying to come up with a plan so you can eliminate the potential for robbery.
I think the best way to eliminate that potential robbery is to have a very high security profile, the security guards, the cameras, the drop safes, the requirements that you don't store cash overnight. Whether the patients want to pay with a credit card, a debit card, or an ATM, I think is secondary to the security posture. And when you're hearing about these robberies, while I don't know the personal facts that were personally with those facts that led to those, I would suspect you have a breakdown there somewhere in the security process that leaves the people vulnerable to this sort of thing.
Well,
So it's not about the transaction; it's about the security profile of the facility.
Well, they buzz, they have admission, they pull the gun, and give you your money. I mean, the one that happened on Ventura Boulevard, I was there at that scene after the shooting. They went in 2 individuals. The owner of the establishment sitting at the counter pulled the gun. He got up to run to the back, and they fired and hit him. It was that quick. They've robbed a number of them along Ventura Boulevard. And it's easy to identify the locations. Just look at LA Weekly. So I'm just trying to come up with a component that can reduce the potential for people getting shot and those establishments getting robbed. You go rob a bank, the FBI is going to come after you. You rob a medicinal facility, you have the local police, and that's about it.
Well, yes, and you know, that's a tragic situation, and of course it is the exception and not the rule.
Well, there's been a lot of robberies. There's been a lot of robberies.
There are armed robberies. That the Bank of America up there on La Cienega gets robbed all the time, but even though these incidents do occur, they're certainly not the norm, and when a person enters one of these facilities, they should already be properly identified before they come in. So we always like to say no strangers in the building, and that's not just a warm and fuzzy membership thing. That's a safety thing. People should be identified prior to entering the facility. So
Don't
that's
they
not an option for them to
they
be
buzz
honest.
through the one on La Cienega where they've got guards, armed guards? They buzz them, they check the ID.
They check it outside, though. They have the person
The
pass
outside?
the ID in. And
But it's all different. Every place has a
it
different.
is. It's all different. And the minutiae of the various security postures is probably not what you guys want to hear this late in the afternoon. But the fact is, medical marijuana facilities themselves are not so unsafe that they can't exist. They can be regulated. And a responsible operator is going to do everything in his or her power to protect the patients and to protect the staff and to protect themselves. And so even though the terrible tragedy did happen, it's by no means typical of medical marijuana facilities, and the fact that this sort of violence occurred in these instances doesn't speak to the fundamental legal issues around transactions. Medical cannabis...
So I'm just trying to find another component to eliminate that aspect of it, the crime aspect.
By all means, let's have the toughest possible security procedures we can in this ordinance. I think everybody in the room would support that.
Which is an additional cost to the vendor.
I'm sorry, say
That's
that
an
again.
additional cost to the vendor.
It would be an additional cost, but I think it's certainly worthwhile.
Thank you.
Councilman?
Thank you. I also had a question. It's okay. Thank you. I also had a question on the pre and post dispensaries from the time we put in our interim control ordinance. And I want to ask the city attorney: is there any issue with starting fresh and not giving any type of special treatment to our pre-dispensaries here, that, like, I don't know, there's some legal kind of expectation that if we adopt a new ordinance after the ICO, we owe them something, or can we, I'm just asking a question.
Jerry Burge, City Attorney's Office. That's a policy question.
So we could actually, there's no legal impediment. And because what I'm thinking is, we're saying that for the existing 187 or so, you have to comply with these regulations after 90 days?
90 days.
90 days.
We moved it to 6 months.
We moved it to 6 months. 6 months. So then, I'm thinking, okay, let's say they are within 1,000 feet of a school, right? And they have to comply. So they get up and move, but they have that special status of being able to operate simply because they applied before the ICO. And I'm just leaving this out there as a question to consider, and I probably need more information. Can I get a report back from the planning department as to, of the 187 pre-ICO dispensaries, how many of them would have to comply with the distance land use requirements that we are putting in? Go ahead.
Point of clarification, the 187 or 86 that were quoted were the ones that applied after the effective date, within 60 days after the effective date of the ICO.
Okay.
So the ICO was already effective.
The ICO was already effective.
Yeah,
those are the ones that
those are the ones that would qualify because they fall within that window.
Okay. Of those, is there 186?
It was approximately 186, 187.
Oh, okay. Well, the 186 or 187, how many of those, before we get to council, when we get to council, would need to comply with the distance requirements or any other obvious land use requirements?
Well, I'll defer to the city attorney on the requirements, but based on the testimony that was just provided and the revisions that were given in this hearing, initially it was they would have the 90 days, but now the request that it be extended to 6 months.
Yes, but I would like to know of the 187, and we've already started mapping these out, so we kind of have some of this information readily available to us. Does the planning department understand the question?
Mike LeGrand, Department of City Planning. Yeah, we have that data and we can compile that for you using the 500 foot, was it, or the 1,000 foot? With the 1,000 foot radius to sensitive uses, we can put that in our GIS system and look at that and run a few different scenarios.
Okay, and thank you very much. And well, not only the 1,000 foot radius, but any other obvious land use requirement that we're putting in the ordinance that they would have to comply with to get a sense of, it may be that all 187 have to get up and leave and move somewhere else. And does it then make sense to have a special status for these or not? I mean, it's kind of looking at the practical effect of what we're adopting. We may see some issues out there we didn't recognize. I'm just trying to get more information on this to see if we're approaching this the right way.
Very good point. We'd be happy to get that data for you.
Okay.
I have a question for our city attorney.
City attorney.
That you take a breather, Mr. Weezer.
I'll take a breather. Okay.
We come up with an ordinance that permits over-the-counter. What's the city attorney going to do? We come up with an ordinance saying that they can do sales for exchange of currency. What's the city attorney going to do if we come up with that ordinance and we get the votes to pass it?
Heather Aubrey, City Attorney's Office. Just a point of clarification, over-the-counter sales is not a critical term from our legal perspective, sales of any nature.
All right, sales.
Okay. Now, with respect to what the city attorney or city attorney's office would do, I would decline to speak necessarily for the city attorney himself on this issue. However, if the city attorney's office determines that an ordinance cannot be approved as to form and legality, then it may not be so executed.
Can we do an ordinance in spite of that direction by the city attorney?
Yes.
Yes. I can answer that, Jerry Birch, with the City Attorney's Office. Yes, you can adopt an ordinance that has not been approved as to formal legality. Whether you should, of course, is a different issue.
Okay. Thank you.
Thank you. And do we have in the ordinance that no dispensary will be allowed within 1,000 feet of another dispensary? We do. That's in there. Okay. And signs, we took out any reference to signs, correct? So that would be dealt in this.
I would object to that. We need to put that in.
Yeah.
We have signs. Jerry?
There's a legal basis for that, and we can talk about that later, but there is a legal basis for the reason that we removed that.
That's a closed session discussion.
Closed session item.
Okay.
Okay. Well, can we, I don't know, I'd like to hear the answer. I know it's a closed session item because
You can have a closed session afterward.
But no, you can't regulate based on content, so we can't specifically refuse to allow somebody to have an on-site sign. We don't do that anywhere else in the city.
I see.
So we cannot regulate on the basis of content.
First Amendment issue.
Could we restrict word? Could we restrict a word?
No.
Okay.
Unless it's obscene.
Yeah, because, it's my view that if we have these facilities that are operating within rules and guidelines, and people who are going there legitimately need the medication, we wouldn't have to have land use guidelines that they have to be 1,000 feet from anything, because you would expect people to go there and purchase their medication and move on. And one way of dealing with that is not to have advertisement that you are doing such a thing, right? But if we can regulate that based on content, it kind of defeats that purpose, right?
Regarding content, what about advertising? What about restricting advertising? Not content, just advertising itself.
Same issue. We can look at that in more detail to see what kind of signs. I don't think there's anything that we can regulate because of this, but we'll look at that. But I just do want to clarify, and you keep talking about this 1,000-foot. I know we're in the Planning and Land Use Management Committee, and this item has been in here because of the interim control ordinance, but we're really regulating pursuant to the 1,000 feet in it for public safety reasons.
For public safety reasons, I see. Okay. Got it. Now, my final question for today is, the ordinance has a requirement that these facilities have bars on all windows. Is that accurate or not? That's correct, right? I'm just wondering if there's some other way, and I suspect this is to prevent break-ins, etc., but we may be adding to more blight in the neighborhood that perhaps, let's say the local neighborhood doesn't have bars on windows. I'm wondering if there's other ways to ensure the safety of this facility that we require them to have alarms. But to ask each facility to have bars on windows, I think will have some neighborhood effects. And also, there may be other means of dealing with this, with a safety issue that we're trying to get at.
Policy question.
Policy question. I would ask, if we could get a report back for full council on the draft ordinances, requirements on safeties, if we could identify those, and compare the windows on bars, and whether there are alternatives we could provide to get to our goal of preventing break-ins at these facilities.
Councilman Starr, one of the things that I want to propose as committee is with the intent of getting this to the full council, that we review next week what is being proposed in writing, so that way we can get the ordinance in its complete draft.
Okay.
And then release it, so we'll know what we're reading before it leaves committee.
So you're requesting that this come back to us in 1 week?
1 week.
Okay.
All the changes.
The changes, okay.
And then we'll have to go to council.
Okay, and including those 3 purpacks, good.
Right,
Good.
and then it gives us... Okay.
This matter was also referred to Public Safety Committee. I want to make that clear.
This is going to Public Safety
It has to
Committee?
go to Public Safety Committee. It was also referred, both the second and third draft ordinance has not been heard by the Public Safety Committee or the recommendations for the revisions. So it won't go straight to council, and when it does get to council, it'll require 12 votes, unanimous votes in council to pass on the first reading.
Okay, so the report backs that have been asked for, because I want to respect Councilman Rizar's review of the ordinance. You want to just let it go to public safety from here?
I'm fine letting it go to public safety.
We can move it on, because it's going to be, I have a good feeling it's going to be in public safety for at least 2 or 3 meetings.
And then have those report backs anytime before it gets back to council, and send those report backs to this committee. Members of this, just send the report back to members of this committee.
Well, I can also refer the request for the reports before to the public safety. They may want additional information. I just don't know what the time would be for the ordinance. The information was just provided so that you know that the ordinance has also been referred to the Public Safety Committee. But along with your recommendations that there be report backs, just would depend on the timing on how you want to move it forward.
To save time, that my staff just clarify, we can just post what's been written, so that way we can see what's being contemplated. It's still going to be a Public Safety Committee, and then we won't waste that week. We can keep moving it forward.
Okay. Sounds good. And finally, okay, I'll leave it for now. I think, like I said, there's a number of other issues we need to still iron out.
Well, I'm in the same place you are, Councilman Mayor and Councilman Zine. There's still some open-ended questions, but I think we need to let it go, move it forward. Public safety will not review it. We can get the ordinance as drafted, given all these recommendations, that will be posted so that everyone will have access to it. It'll be very, very transparent, so there's no hidden agendas here. We're trying to reach the balancing point, and we can move this thing forward. So I went through the list of instructions. If we can get a support on that, we can just move it on. Councilman? I have a yes on Councilman Zine. Yes. Councilman Zine?
Yes.
Okay, so...
One last point of clarification. Did you want the ordinance back in this committee next week, or want to move it to public?
Let's move it on.
All right.
Let's move it on. And so we got the planning side of it. Already, instructions are pretty clear?
Yes.
Okay. All right, so that takes care of 1A, B, C, and D. And that'll be the last of the marijuana ordinance in this committee. Thank you very much. Roberto? What's left? No, do we have 4?
Yeah.
We do?
Yeah, I think we have 4.
Okay.
Because we had speaker cards on 4.
4 is a hardship exemption from the Windsor Village ICO, and it's for the replacement of texture coating.
Do we have staff here on number 4?
There is no staff. It's simply a hardship exemption request.
Okay, so let's hear from the applicant for the hardship exemption.
The applicant is Richard Kramer. Okay. You're the representative or the owner?
This is Barbara Williams.
Okay, she's your representative.
Actually, my name is Barbara Williams, and I simply, I'm an expediter, and so I am the one that goes to get permits and things for Mr. Kramer. And I just want to start by saying he is a longtime resident of the Windsor Village community, and as such, he does have an interest in preserving the aesthetic appeal of that community as well as the value of the property there. We've gone through several processes for getting the permits necessary to do repairs and things on his property. And so now he's simply asking for this in order, and it's all been set forth in the findings that were submitted with the application. He wants to re-stucco his home. He has right now a texture coating on that property, and the texture coating has a life of about 15 years, which is coming to an end. And so now he simply wants to do that. We already have a permit to do the stucco, and our The application that we have before you today is simply to request that we be allowed to do a smooth finish rather than the sand float with the medium grit. It's that simple. It's not anything more than that.
Okay.
And so we've shown in that, if you look in the application, you'll see that we found another property that was being cited as a historic cultural monument there, and it was an application put in for that. And it shows that in 1919, that property was built and was finished with a smooth stucco finish. We have photos of that property, and I also have samples of the stucco finish that we desire to put on the property today. Yes, and we have all, and also, well, in the application, you'll see there were photos of other properties in the area that do have a smooth stucco finish.
Okay, so Ms. Williams, you're representing Mr. Kramer?
Yes,
Okay. Anything else you'd like to add?
I'm sorry?
Anything else you would like to add?
Not at this point. Mr. Kramer is here. I think he wanted to add some things himself.
Mr. Kramer, okay?
No, we've gone through all of the processes and already have the permit and have done started to do some of the work. I simultaneously previously had started working to put up a garage, which also was approved through hardship. So everything that we've done has been approved and has got permits, and we are abiding by those and working with those permits. And this is, again, just to have the smooth stucco. And if you were to drive the neighborhood and look around, in fact, the neighboring houses that are pictured there have that smooth stucco finish. I have samples if you'd like to see the difference in the samples. The picture of physical samples. Barbara, do you have those physical samples, please?
Okay.
Can I approach?
You just pass me the clock, please.
I have a question.
Okay.
Smooth finish that you see, and I think that enclosed in the package are the photos of the 1919 property that has that same smooth finish. And on the garage, there was no, when I got the garage permit, there was no denotation as to a sand medium float finish. There was no denotation. So, you know, after the garage started to be built, I decided to then repair the other work so that the garage and the home would then match. And I had several contractors come out and they say your texture coating is deteriorating, and in time if you do stucco over it, it's going to remove itself from the building, and there could be other issues by just covering up what's existing there and putting a finish over it. So we are sandblasting. We have the permit to sandblast. We haven't started the sandblasting, but many homes in the neighborhood, in fact, there's a property right in back of mine that is sandblasting and has a permit. The scaffolding is up on it as well. There are structures in the neighborhood that are half done that have been blasted or being repaired.
Okay, sir. Thank you very much.
I got a question.
You have a question?
I got a question. Is there any restriction on the color that you apply?
There are parameters of the colors, and we've submitted the samples of the color within that parameter, but there...
you have to get approval for that too?
There are no restrictions. I mean, the house next door, they could paint it any color they wanted to paint, and there doesn't seem to be any restriction.
You could paint it pink, blue, turquoise. There's no restrictions on the color?
We submitted a sample of the color that we want in our property, or a close proximity of that color. As you know, color as you put it on changes a little bit differently.
Right. Okay.
But we're looking to have it much the same color that it has been for many years.
Okay. Thank you.
Thank you. And one last thing is, you know, the way that I'm looking to do it is actually more expensive and is more appealing than the texture coat that was on there, which is a low-cost way to protect a home, but doesn't last forever.
Right.
Okay, thank you, sir. We have Julie Grist and Charles Doherty. This is the last one.
Hi, I'm Charles Doherty. I'm president of the Windsor Village Association, and it's kind of coincidence because we came here for a different matter but saw this on it. And I'm hearing what Mr. Kramer wants to do, and the issue of taking the texture coating off and doing the clean trial cement on it, is actually something that I think would be background information. You understand that we're in an ICO moving toward becoming an historic district, okay? So everything that has to be done, that's why he's here, okay? In terms of doing that particular thing to the house, I think it probably would be something that would be in line with historic preservation. Just anecdotally, in terms of observing and walking in the neighborhood, my only concern, and would hope that Mr. Kramer would be planning on putting the pilasters, which are an architectural feature of the house around the windows. They've been removed, and I'm imagining that you did that so that you could see. You had to take them off to take the texture coating off. Yeah. Okay, that's good. Yeah.
You know, it's like.
Okay. Come on, so that's,
Yeah.
I can't have a debate on.
I'm going to, then
Next
part.
speaker, please.
I'm sorry?
Next speaker, please.
Yeah, okay.
Yes, I'm Julie Grist. I live at 907 South Windsor. We really think the new plaster job is fine. We don't really understand why he is here, the applicant is here, because he knows the process is to come before the Windsor Village Association Historic Board, which we did with him already with a garage, which we gave him approval. What we're worried about is that he has bigger plans, because he also took off, there's a large arched wall that went from his driveway, which is one of the key significant things that make his home Spanish colonial, and he just chopped that right off recently. So our only concern is that he has other plans than just the plaster. He did take off these integrated pilasters, which are spiral pilasters, at the front window section, and I don't know if those can be replaced, because once they're chopped off, they're chopped off. So we don't want him to do anything else. He could really have just come to us for approval and saved you all some time, I believe.
Okay. Vince, is you?
Vince Bertoni, Deputy Director. There may be a little confusion here. What I believe the situation is there's an interim control ordinance in place in Windsor Village in preparation of of historic preservation overlay zone. There is no historic preservation overlay zone established for Windsor Village. Therefore, there is no city process an applicant would need to go through for approval, because in essence, you can't do work on your house because there is a ICO, which doesn't allow that unless you get a hardship exemption. So there is only one process that I know of in the city of Los Angeles to do this approval, which would be a hardship exemption, which the applicant is doing appropriately. Now, the neighborhood association may have its own separate review committee, and that may be what the last speaker is talking about, but that's not a city process. That's not something that this applicant needs to do to get approval for what he's asking for today. He just needs to go through the hardship exemption, which he's applied for. Okay. And he's done, I believe, he's gone through the correct process.
Okay, seeing no other speaker cards, I know we've been consulting with the council officer, not here at the moment, but I believe we wanted to recommend approving the hardship exemption, and that I weigh very heavily, and based on the facts before us, that would be my motion to approve the hardship exemption. Have a second? Second. Okay, that'll be the action of this committee. Anything else, Roberto?
There is one other item before Roberto makes the public comment issue, or very public.
Okay, very public.
Yeah, I just want to go back. What was it? Item number, it was the item related to the medical marijuana, number 4, for the hardship exemption for the medical marijuana dispensary. I think there was a request for several report backs from the Department of Public Safety, City Attorney, and LAPD related to enforcement and prosecution, as well as some other issues. And then I realized that that's a denial of hardship exemption. So what I'd like to ask the committee to do is to fold those report backs in with the other report backs that are on the medical marijuana issue, so that when they do get the report backs, they'll have them collectively related to the same matter.
Okay.
As opposed to individual hardship requests.
That sounds like a good strategy.
Thank you.
Okay, we'll go there. All right. So just wrap up all the report backs under one umbrella on that subject.
Thank you.
Thank you, ma'am. All right, anybody have public comment? Seeing none, this meeting is finally adjourned. Thank you.
Did you say finally?